initiative's mission is to shape policy, defend rights, and build capacity in the digital environment towards an inclusive and rights-respecting world. And as the digital landscape evolves, safeguarding fundamental human rights is paramount, which is why we're here today. So our aim is very clear: to drive policy change that upholds freedom of expression, media, and digital rights legislation in Nigeria. This requires a collaborative effort to navigate ongoing legislative and policy development processes. So between today and tomorrow, we're going to embark on collective, collaborative advocacy for specific legislation. So the Cybercrimes Act, Online Harms Bill, and the Digital Rights and Freedom Bill. We've brought everyone together as experts, people who we believe have valuable insights to this process and input to influence the trajectory of digital policy in Nigeria. So each and every one of us has valuable insights and input, and a collective push will pave the way for meaningful change, ensuring that our laws and policies align with the principles of human rights and digital freedoms. So I'm glad we also have press coverage here that will help us to disseminate, because one of the things we also need to be intentional about is ensuring that it's not just the usual suspects in the room, those of us who are really passionate about digital policy, but ensuring that each and every Nigerian also is aware of these laws and how they affect their everyday lives. So thank you again, and I urge everyone to actively participate, share your insights, contribute to our shared goal, and harness the power that we have in the room to shape a future where digital rights are respected. So welcome again, everyone. And this is to a fruitful collaborative process today and tomorrow. I'll also take the opportunity to thank our partners, the Netherlands Embassy Ministry of Foreign Affairs, who are funders of this particular project, the stemming project called STAND, Stemming the Tides Against Abuse in the Nigerian Digital Space. And it is under this project that we are holding this workshop series and advocacy series. So welcome everyone, and a big thanks to our funders. Hopefully we'll have them around today or definitely sometime tomorrow. Welcome everyone, and have a great deliberation.
So I'd like to welcome the Executive Secretary of the National Human Rights Commission, Anthony Ojukwu, SAN, OFR, represented by the Director Legal Services and Enforcement, Mrs. Rabi Anwar. Thank you.
I represent the Executive Secretary, National Human Rights Commission, Dr. Tony Ojukwu, OFR, SAN. I'm going to start with a little introduction about the Commission and our mandate. So the National Human Rights Commission is an institution of government established by the National Human Rights Commission Act 1995 as amended. This is in line with the resolution of the United Nations General Assembly enjoining all member states to establish national human rights institutions for the promotion and protection of human rights. The Commission serves as an extrajudicial mechanism for the enhancement of the enjoyment of human rights. Its establishment is aimed at creating an enabling environment for the promotion, protection, and enforcement of human rights. It also provides avenues for public enlightenment, research, and dialogue to raise awareness on human rights issues. The NHRC Amendment Act in 2010 has conferred on the Commission additional independence and strengthened the Commission's power with respect to the promotion and protection of human rights, investigation of alleged violations of human rights, and enforcement of our awards and decisions. The Amendment Act has also widened the scope of the Commission's mandate to include vetting of legislation at all levels to ensure compliance with human rights norms and standards. Consequently, this means that the Commission is also entrusted with safeguarding the digital rights of Nigerians and non-Nigerians alike resident in Nigeria. This is because rights are being abused and violated within the digital space the same way they are infringed upon in the physical world. In line with her mandate, I stand before you representing the Commission and the Executive Secretary, honored to address stakeholders on this digital engagement series. On behalf of the Commission, therefore, I would like to recognize and applaud the continued efforts by Paradigm Initiative in promoting digital inclusion and protecting digital rights in Nigeria especially, and Africa as a whole. Paradigm Initiative has shown eminence in the digital rights space and continues to lead through programs such as the Digital Rights and Inclusion Forum, the Net Right Coalition, its fellowship programs, training workshops, some of which the Commission has benefited from, workshops, and countless advocacy and community engagements in Nigeria and across Africa. The Commission has taken notice of the expertise and leadership Paradigm Initiative has taken in getting the Digital Rights and Freedom Bill introduced in 2016, reintroduced again in 2019, and the current effort to reintroduce it to the 10th Assembly. Thank you on behalf of Nigerians for your tireless efforts. Legislative frameworks such as the Cybercrimes Act of 2015 and the Data Protection Act of 2023 are vital to the Commission within the broader context of promoting and protecting these fundamental rights. Nigeria must combat cyber threats while simultaneously upholding the digital rights of its citizens. The Data Protection Act of 2023, in keeping with its global best practice, highlights 8 digital data subject rights: the right to be informed, the right of access, the right of rectification, the right of erasure, the right to restrict processing, the right to data portability, the right to object, and the right to not be subjected to omitted decision making and profiling. The Data Protection Act of 2023, alongside the Cybercrimes Act of 2015, and other legislation such as the Electronic Transaction Act of 2011, the Freedom of Information Act of 2011, and the Communication Act of 2003, etc., signify crucial strides towards a comprehensive legal framework aimed at addressing cyber threats, protecting digital rights, and promoting the secure and responsible use of information and communication technologies in Nigeria. It is essential, therefore, to adopt a holistic approach that encompasses the multifaceted dimensions of digital rights. As stewards of human rights, we must emphasize the importance of striking a balance between enhancing cybersecurity measures and safeguarding citizens' rights to privacy, freedom to learn, freedom of speech, freedom of expression, and due process, which the Digital Rights and Freedom Bill seeks to address. Furthermore, we must recognize the significant role of the National Human Rights Commission in advocating for the alignment of digital policies with international human rights standards. Legislation in this domain must reflect the principles of transparency, accountability, proportionality, and the CIA of data privacy, namely confidentiality, integrity, and accessibility, thereby ensuring that the rights of Nigerian citizens are respected, upheld, and protected in the digital space. Finally, as we continue to navigate the complexities of digital policy, it is obligatory upon us to foster inclusive dialogue and collaboration among all stakeholders, including government agencies, civil society organizations, the private sector, and the broader public. Let us remain steadfast in our commitment to upholding the principles of human rights, ensuring that our digital policies reflect the values of democracy, justice, and respect for all. Thank you for your attention.
Mr. Yusuf A.A., representative of the Director of Public Prosecutions, Federal Ministry of Justice. But his speech is not here yet, so I will invite Adeboye, who I cannot see in the room. I would invite Adeboye Adegoke to start us off, and then Mr. Yusuf, you'll most likely come after that.
My name is Adeboye Adegoke, and I'm with Paradigm Initiative. And my job this morning is to set the context for today's dialogue. Why are we here, and why are we having this conversation today? Nigeria, like the rest of the world, is grappling with the challenges that comes with the governance of the cyberspace, and there are a lot of opinions and perspectives in terms of how best to approach the governance in terms of whether regulation or legislation of the cyberspace. I think the first significant legislation that Nigeria made with respect to addressing some of the challenges being encountered in the cyberspace was the Cybercrimes Act 2015, which at the time was responding to challenging with cyber criminality. You would agree with me that around that time, leading to 2015, between 2010 and 2015, Nigeria was very notorious for what we know as Yahoo Yahoo, right? And there were calls from all over the world in terms of a need to respond to this challenge as a country so that we also protect our name and our integrity as a nation. So when the conversation around the Cybercrimes Act in 2015 was happening, I think everybody who was working in the digital sector was kind of, enthusiastic about it. There were massive support in terms of the fact that Nigeria needed to enact a law that punish cyber criminality and other forms of online harms at the time. But as at the time when the law was enacted, it was obvious that there were also problems. But it's also like when you are trying to solve a problem, then in the process, other problems come up. And from a civil society perspective, we started bringing attention to Section 24 of the Cybercrimes Act. Immediately, the act was enacted, despite the fact that most of us supported, the enactment of the law at the time. And so our concern at the time was around the language of Section 24, which was described as cyber stalking. We tried to warn the nation at the time that those provisions are too vague and there is no way it would not conflict with the constitutionally guaranteed right to freedom of expression in Nigeria. And I remember very vividly then, at the office, I used to have a spreadsheet whereby whenever somebody gets arrested for something they said online, and references were made to Section 24 of the Cybercrimes Act, I will literally take note, I'll put it on that spreadsheet. And in 2015, 2016, I can tell you categorically that in a year, we might probably see 5 to 6 cases happening. But by the time we got to 2019, thereabouts, the number of people who were getting arrested for things they said online became so massive that you couldn't even capture it on a spreadsheet anymore because it was literally just happening every day. Almost everybody who has some sort of connection, power, influence is getting somebody arrested because probably they got involved in a heated argument online. In some cases, insults, they said insult. In some cases, disrespect. So everybody was leveraging that provision because the provision was very broad, vague. So anybody can just take advantage of it and go after whoever has said something they don't like. And recently, I'm sure we are all familiar with the current or the ongoing case between the tomato company, Erisco, and that's one of their customers who made a review online, who is now facing two litigation, one from Erisco, the other from the Nigerian police. Everybody leveraging the Section 24 of the Cybercrimes Act, 2015. I think since last year, we've been in conversation with the Ministry of Justice. We've been monitoring its efforts to amend the Cybercrimes Act generally. Of course, different stakeholders have different issues that they want to see amended, but for us, we are very key about Section 24. And while we're following that process, in February or so, the National Assembly called for a public hearing on the same Cybercrimes Act. So we're a bit confused and like, okay, what's happening? Is this process in sync with what the Ministry of Justice is trying to do? So we kept communicating to be sure that we are in sync with what was going on. So when we started planning this program, initially what we wanted to do was to use it as an opportunity to have a dialogue about Cybercrimes Act 2015 and come up with some resolution that we can share with the Ministry of Justice as it continues the process of amending the provision of Cybercrimes Act 2015. But about 3 weeks ago or 4 weeks ago, I was actually on leave and I saw on the news that Cybercrimes Act 2015 has been amended. So I was like, okay, it wasn't April 1st, so it couldn't have been April Fool. So I remember reaching out to Khadija that what's going on? Has this bill been amended? And he said, oh yes, they amended it, and she sent me even a copy of the amended version. I'm like, wow, this is interesting. And then it became a conversation internally. We were asking that, well, would this event then be necessary if what we're trying to do has been done already? But then anybody who is familiar with advocacy work would agree that advocacy is a marathon. It's never a sprint. So don't ever get to a point whereby you say, oh, the job is done now, then you can go and sleep. I remember the first advocacy I ever worked on was the Nigerian National Tobacco Control Bill in 2015. And after the bill was passed, and we thought, oh, we've done the work. And then we realized that even after the law was passed, it was just sitting there. Nobody was implementing it. So we now realized that we need to do more advocacy to make sure that the people who need to implement it are implementing it, and also that there is enough, public awareness, education that needs to happen. So even when the Cybercrime Act was amended, we know for a fact that the work is not done, because even the current language too is still, it can still be abused because there are still, contentious, reference, and also because we know that the Ministry of Justice is also ongoing a process of amending that same law. So we thought it's still relevant for us to use this opportunity to look at the amended version of the law, to also have a dialogue around where we are in terms of what does the amendment, what does it mean for us and for the ecosystem, and also an opportunity to also, get to hear about the work that the Ministry of Justice has been doing regarding that act. In addition to that, also sometimes last year, we were invited by the, is it National or Nigeria Information Technology Development Agency, NIDA, because it was starting a process to, it was setting up a steering committee, basically, to come up with, initially it was called a content moderation and digital rights law in Nigeria. But after a few meetings, the steering committee moved from that to what it now calls a proposal for online harms bill. And right now, the steering committee has developed a white paper, which is still an internal document at the committee level. It will be published very soon, and we will hear more from the committee later. And when that white paper was developed, those of us that were privileged to be members of the committee, we were asked to, provide input into the white paper. But as an organization, as Paradigm Initiative, and as a member of that steering committee, I'm a member of the committee as well as being there. We quite understand that our membership of the committee, it is not supposed to be personal, because we represent an important stakeholder group, which is a civil society stakeholder group. So anything we are doing on that committee must be a reflection of the position of civil society in Nigeria generally. So we thought that this is also an opportunity to kind of give, to come back to our constituents to say that this is how we have been engaging with this process. This is some of the conversation that has happened. For example, one of the feedback we have given for the white paper is that some of the things that is being proposed, we think that there is an opportunity with the ongoing process to amend the Cybercrimes Act to, instead of, initiating that through a new law, that we can leverage what is already going on with the Cybercrimes Act. Because we are at a stage as a nation whereby the country is saying we want to cut down the cost of governance, right? A few weeks ago, the presidency announced that they were merging some ministries. So if we are having conversation around creating new laws that will set up new agencies, we also need to be in line with the thinking at the national level to say that, do we really need to, push for creation of a new agency, or perhaps we can leverage existing systems, existing law to address some of the challenges we have. One of the proposals under the white paper is also around harms to children online, and we're also asking the question: would it make more sense to look at the Child Care Act and say that some of the things we want to be addressed should be embraced in an amendment to an existing law? So these are some of the conversations we are going to have today. And what we are going to do is that we are going to provide, in the spirit of transparency and openness, we are going to provide you with some of the information or some of the feedback we have been giving to the committee. in anticipation of the publication of that white paper, at which point it then becomes a public document. But we're also very conscious of our role as civil society organization. If there's anything we advocate for, it's also transparency. So we cannot be involved in a process like that, and our constituents will not be aware of our activity, of our involvement, and most importantly, our position in the ongoing conversation. So let me use this opportunity again to thank everybody who has made it to this meeting. I'm very, very positive that this is going to be a very positive engagement whereby we have an opportunity to listen to one another, to learn from one another, and to advance the cause of right respecting, innovation friendly cyber governance in Nigeria. Thank you very much, everybody.
Mr. Yusuf, AA, representing the Director of Public Prosecutions, the Ministry of Justice. And you know that he came prepared.
Something like that. Good morning, everyone. You know, let me respect the protocol, but please permit me to digress a bit. You know, we are lawyers. We respect our profession. We respect seniority. I will start with my lord. I'm sure he or she is here for the CJFCT High Court. My lord, good morning. Justice Binta Murtala Inyako. Then the Executive Director, Paradigm Initiative, distinguished senators and honorable members that are here present, Your Excellency, the representative of the Kingdom of Netherlands, the Chairman, Nigerian Communications Commission, the National Commissioner / Chief Executive Director, Nigerian Data Protection Commission, Director General of the National Information Technology Development Agency, NIDA, the Executive Secretary, National Human Rights Commission, stakeholders, civil society organizations, gentlemen of the press, distinguished guests, ladies and gentlemen. Let me tender the apology of the Director of Public Prosecution of the Federation, Mohammed Babadoko Abubakar, who wished to be here physically, but I'm sure he's with us spiritually, and his team are here with you. He has to go for another assignment, so I have to come here and represent him. It is with great honor and enthusiasm that I stand before you today as we convene for the Digital Policy Engagement Series hosted by Paradigm Initiative. Our collective presence here underscores our commitment to advancing digital rights, fostering collaboration, and shaping the future of cyber crime legislation in Nigeria. As we delve into the heart of our discussions this morning, I'm reminded of the profound impact that technology has on our lives. The digital landscape is ever evolving, presenting both opportunities and challenges. Our task, therefore, as consensus stakeholders, is to navigate this dynamic terrain with wisdom, foresight, and steadfast commitment to safeguarding the rights of every Nigerian citizen. The Nigerian Cybercrimes Act 2015 stands as a pivotal piece of legislation, a framework designed to combat online crimes, protect our digital infrastructure, and ensure justice prevails. However, like any living document, it requires periodic review and adaptation to address emerging threats and uphold the fundamental human rights. In considering this process, it is crucial to take into account the following. Collaboration and avoidance of duplication. Our collective strength lies in collaboration by bringing in the whole of government, whole of society approach. We can harmonize our efforts, pool resources, and avoid redundancy. Let us use this opportunity to foster synergy and amplify our impact. Identifying complementary legislation. Beyond the Cybercrimes Act, we must explore our bills and legislation that share similar objectives. Our holistic approach demands that we consider the broader legal landscape. By doing so, we can bridge gaps, eliminate contradictions, and ensure coherence in our cyber policy framework. Ongoing work and continuous improvement. The Cybercrimes Act is not static. It breathes and evolves. Our commitment to excellence requires us to provide regular updates on its implementation, challenges faced, and areas for improvement. The Federal Ministry of Justice had kickstarted a series of national consultations on the legal framework and is still piloting this task to bring it to fruition. As we continue to navigate this journey of legislative reforms, we are committed to ensuring that our legal framework remains responsive to the evolving challenges posed by cybercrimes. Our ongoing efforts aim to uphold the integrity of our laws while safeguarding the rights and interests of all stakeholders involved. In conclusion, let us remember that our mandate extends beyond policy formulation. It encompasses the very fabric of justice. As we deliberate, let us keep in mind the young Africans seeking digital opportunities, the vulnerable populations relying on our protection, and the promise of a more secure and equitable digital future. Together, we can shape policies that empower, protect, and inspire confidence in our digital ecosystem. Let this dialogue be a beacon, a testament to our shared commitment to progress. Thank you, and may your deliberation be fruitful and transformative.
All right, thank you very much. The Ministry of Justice. Now we'll be having our partners from the Kingdom of the Netherlands. We will be having Jessica Odudu, Senior Policy Advisor, Politics and Human Rights from the Kingdom of the Netherlands.
Good morning, everyone. Good morning, ladies, gentlemen. Everyone looks so lovely in the room. My name is Jessica Odudu. I am the Senior Policy Advisor on Politics and Human Rights to the Embassy of the Kingdom of the Netherlands. And on behalf of the embassy I represent, I would like to say it is a pleasure to be here and to be at this very interesting point in our digital rights legal history. As we convene today, let us collectively recognize the profound significance of advancing the digital rights landscape within the Nigeria's legislative framework. We stand at a pivotal juncture in history, as the representative from the Ministry of Justice rightly says. The world is undergoing a rapid transition into the digital age, representing unparalleled opportunities alongside potential challenges. With approximately 84 million and counting internet users in Nigeria alone, the urgency for this dialogue cannot be understated. It is important to establish and strengthen frameworks that harness the potential of the digital innovation while safeguarding against the perils of abuse, mis- and disinformation, and other vices of the internet. Indeed, nations worldwide are grappling with this reality. endeavoring to strike a balance that ensures the promotion of freedoms while safeguarding users. It is interesting to see that the Cybercrimes Act, which was once a response to this need, is being reviewed again to ensure that it not only enhances the space, but is a tool to safeguarding and promoting the freedoms of you and I on this very, very interesting technology called the internet. As a strategic partner to Nigeria, we are happy to have contributed to this initiative, understanding the significance in promoting interagency collaboration, cooperation, and dialogue in harnessing collective input to ensure we create a law that is of us, for us, and by us. In closing, I extend my appreciation to Paradigm Initiative for their commendable efforts in convening this dialogue. Their steadfast commitment to advancing digital rights and advocacy has played a pivotal role in mobilizing stakeholders and fostering inclusive dialogue. I wish all participants a fruitful gathering and look forward to learning from your contributions and insights on this law. Together, through our collaborative efforts and shared commitment, we can work towards a digital landscape that upholds the principles of equity, justice, and freedom for all. Thank you very much.
All right, a round of applause again for Jessica from the Kingdom of the Netherlands. And a huge thank you again for them for making this possible. So now we'll be inviting Chamila Kongade from from the Head Cybercrimes Unit, Federal Ministry of Justice. Thank you for a welcome remarks. A round of applause as she joins us on stage, please.
I would like to say a very big thank you to Paradigm Initiative for convening this. This is really very timely. And you cannot overemphasize the need for such platforms. You can never get tired of advocacy because this is the way forward, and especially on a matter as cybercrimes, which is ever evolving and needing the involvement of everybody. So this morning, my task is very simple. I'll be talking about the Cybercrimes Act, the role of the Federal Ministry of Justice, the journey so far, and then highlight a little bit on the acts in action. My presentation will have 5 key, items on it. First, I would like to start by talking about the key issues that led to the introduction of the Act. I would speak on the Act in action, and then the journey to the amendment, the role of the ministry, and lessons from the entire process, and how we can all support the process. So permit me to acknowledge the effort of my colleague, Leyi Abwe, who worked hard on also making this paper this morning. Okay, so just like a background, in 2014, in the bid to address the evolving cyber threats and ensure the efficient use of the internet, the Office of the National Security Advisor took steps and a strategy and policy document was adopted. And this gave birth to the 2015 Act, the Cybercrimes Prohibition Prevention Act 2015, which was recently amended. I will talk about it just along the line as we proceed. This policy and strategy document, which was birthed, had 3 key approaches. There was a public-private sector partnership, there was the multi-stakeholder engagement, and then it also had international cooperation, which all harmonizes the strategy. One of the strategic focus of this act was to develop an appropriate cybercrime legal framework, which is what I said gave birth to the 2015 Act. So while this act came before Nigeria acceded to the Budapest Convention, which took place in 2022, July 6th precisely, it was largely modeled after the Budapest Convention. So I'd like to mention that the Budapest Convention on Cybercrime is at the moment the only close to global existing framework.
and that's a Council of Europe's document. It has two protocols, the first on xenophobia and the second on, what do you call it, digital evidence. All right, so just, I would just like to note a few things about the policy. In 2021, it was amended. Just like any living document, there's got to be what I call it provision for review. So 5 years after, it got reviewed, and then in February 2021, it came up with a new document, and 8 pillars were included in that particular document. The first is strengthening cybersecurity governance and coordination. Second is to foster protection of CNII, the Critical National Information Infrastructure. The third, to enhance cybersecurity incident management. The fourth, which is a very particular interest for me, is to strengthen the legal and regulatory framework. We also have enhancing cyber defense capability, promoting a thriving digital economy, assuring monitoring and evaluation, and then also enhancing international cooperation. Forgive me if I'm talking too fast, but I'm sure somehow you're following. And just like I said, those are just a few highlights. So I would like to make it brief, even though I saw that the time allotted to us was quite a lot. But I'll prefer that we get engagement from participants rather than just having it a one-sided presentation. So the objectives of that particular 2015 Act, which now has a different phase, are as follows: to provide an effective and unified legal, regulatory, and institutional framework for the prohibition, prevention, detection, prosecution, and punishment of cybercrimes. Second is to ensure that critical national information infrastructure are protected. And we understand how important this is, because once any national information infrastructure is crippled, the nation is also crippled. We've heard of nations that have been crippled just because some critical information infrastructure were toyed with. We've seen the issues of the colonial pipeline and how countries have suffered largely debts and all of that, things being stalled, all because they were not properly protected from emerging issues such as ransomware, for example. The third is to promote cybersecurity and the protection of computer systems and networks, electronic communications, data and computer programs, intellectual property and privacy rights. And this very act covers designation and protection of critical national information infrastructure, even though it's not been listed, but somewhere at the very start of it, it gives powers for designation of certain networks and computer systems as critical national information infrastructure. It criminalizes conduct. So you would find out that we have computer-related offenses such as forgery, theft or fraud, content-related offenses such as child pornography, now taking on a new semblance, online child sexual exploitation and abuse. We also have offenses against integrity, unauthorized modification of computer systems, network data, and system interference, And we also have offenses against availability and confidentiality of systems and network. All of these have been criminalized under the Act. It also provides for procedural provisions, investigation, prosecution, and general enforcement. And lastly, it provides for jurisdiction and international cooperation. So like I said earlier, though the Act came a long time before, about 7 years or thereabouts, before Nigeria acceded to the Budapest Convention, it was largely modeled after it. And this is because one of the requirements that the Council of Europe has for any country to join is an alignment of your laws. In case you do not have a national law covering cybercrimes, you should have one just before you join in, which some way, somehow aligns with the convention, with the provisions of the convention. And a number of our provisions in the 2015 Act line up they align with that of the Budapest Convention, such as illegal access, illegal interception, data interference, system interference, misuse of devices, computer-related forgery, computer-related fraud, and child pornography, all under Part 3. The Act establishes the Cybercrimes Advisory Council, of which the chairman of that particular advisory council is the National Security Advisor, and the Honorable Attorney General of the Federation is also a member, and quite a number of other agencies which may be represented here. And that it empowers the Office of the Honorable Attorney General to do three key things, which is to strengthen and enhance the existing legal framework to ensure, one, the conformity of Nigeria's cybercrimes and cybersecurity laws and policies with regional and international standards. This is very important. The second is to ensure that these laws are strengthened and enhanced in a way that international cooperation is maintained. And then lastly, that cybercrimes and cybersecurity matters are effectively prosecuted. And it is based on this that I stand before you from the Office of the Attorney General to speak as an authority about strengthening and enhancing legal framework as it relates to cybercrimes and cybersecurity in Nigeria. So why do we really need an amendment, basically? Permit me, I'm giving this background because though some of us may be in the ecosystem, it's important for us to get all of this, which would help us have much more beneficial engagement when it comes to iterating what it is that we think are the next steps and the way forward as a nation. So the cyberspace is constantly evolving, and we certainly have emerging issues. As at the time that the 2015 Act was done, there was not an issue that was really rising as hard and hitting many countries now, even getting into Africa, as hard as ransomware. And this is as simple as it may look. It's, like I said earlier, it's really becoming a big issue, a big challenge, to the extent that we have now one of the biggest international partnerships, which has been led by the US, which is called the International Counter-Ransomware Initiative, driven where you now have nations and you have international organizations like the Europol, Interpol, even the Council of Europe and the GFCE, Global Forum on Cyber Expertise, all becoming a part of it, because nations have to have their capacity built to get an understanding of this very issue, such that they'll be able to address it properly. And particularly with rising issues, that the fact that payment for some of those ransoms, when it comes to ransomware, is being done with the use of virtual assets, cryptocurrency. So it's important, for one to be able to just get an understanding of it. So why do we need it? Why do we need to amend our act? That is one of it. And secondly, a key area of interest for us as a nation is international cooperation. And we understand this very well, that if international cooperation is a tool for combating cybercrimes, then it's important that you have provisions in your law that would make people want to cooperate with you. For example, if a country has issues of child online protection that is very important and they hold at heart, to them as a nation, if you do not have such, it might be quite a big challenge for them to want to cooperate with you when it comes to combating cybercrimes in a particular area. Nigeria is now a party to Budapest Convention, like I mentioned, and like being a party to any international document, any international agreement, you have obligations, and part of it is to align your own laws domestically to ensure that it reflects some of the obligations that you have, either as parties or whatever it is, the status that you have under that particular international convention. And so as Budapest Convention party members, Nigeria is expected to align the domestic law to the provisions of the Budapest Convention on Cybercrime. For example, most recently, Article 19 was one of the key things that we had to respond to, because they carry out periodic assessments of parties on how, for example, the search and seizure provision of the convention is being implemented in our national laws. So it's important that over time, when these things occur, you're able to look back and see how much of these are reflected in your national laws. And also lastly, on this, Nigeria is very active at the ongoing negotiations for a global treaty. I told you the Budapest Convention is the only close to existing global one. It's a Council of Europe document. It's not a United Nations document. And we now have a negotiation that has been ongoing, and Mr. Boye has been involved in that process. We've been meeting there, and we are almost at the concluding stage. It's a United Nations process that has been launched, and hopefully it should give birth to a global document which is going to deal with cybercrime. So Nigeria has been very active. In fact, my predecessor is the vice chair. So Nigeria is fully involved even at the leadership of it, and then also in the deliberations. So at the end of the day, if a document or when a document is adopted, it's important also that we also reflect some of these provisions in our own national law, domesticated, such that it also shows forth that the obligations that we have under the international agreement, international document is reflected in our national laws. So some of these thoughts and some of these deliberations are important that we bring them back home to strengthen our own law. So what has the Ministry of Justice done? Remember I mentioned earlier that the Act gave the Honorable Attorney General of the Federation's office powers to do certain things, which is to strengthen and ensure that the existing legal framework does certain things. So in line with this, last year, May 2023 precisely, the Ministry of Justice launched national consultations on the legal framework, not just Cybercrimes Act, so to speak, but looking at it holistically, because it's very important to look at it from a whole of government and a whole of society approach. Like I said, this is not something that even one nation can fight, talk less of having just one arm of government deal with it. So various stakeholders were involved at the national consultations, and we had people who were involved in drafting, prosecutions, investigation, adjudication, as well as the private sector and civil society organizations, all in attendance. And at that particular event, what we had was, we had Council of Europe experts who had looked at the Act as it was. They did a desktop review and they gave a debrief at that particular consultations. And so we had a lively exchange between the participants and the experts. And at the end of the day, we came up with a communique. All participants, not the Federal Ministry of Justice, came up with a communique, and a roadmap was adopted. And as part of the roadmap, the next step was to have a legislative drafting retreat with a small number before the next national consultations. And in line with that, because this is a process that the Council of Europe, what I call it, supports all through. And so we had this legislative drafting retreat last year in Lagos. And like I said again, because it's not a one arm of government scenario, we had everyone that was needed on that. We had academia, we had even the African Union cybersecurity group of experts also represented there. The Council of Europe made sure that we had people who were needed on that particular team to be there, because it's our own document, and the intention is that that document would give birth, that meeting, that retreat will give birth to a document that we will be able to present to everyone again at another national consultations. So like I said, it was a small workforce, which the Honorable Attorney General of the Federation approved, and we came up with recommendations. And along the line, a need arose for the National Assembly to amend the 2015 Act, and it had initiated a process which gave birth to the Cybercrimes Prohibition Prevention etc. Act of 2024, which was signed by the President in February this year. So, the current amendment of the Principal Act, as it stands, which is the 2024 one, the Budapest Convention on Cybercrimes and its protocols, Nigeria's gleanings from international engagements, as well as emerging trends, are currently being considered in the comprehensive review of the legal framework led by the Federal Ministry of Justice. The approach is that which is adopted is that of a whole of government, like I said, and a whole of society approach. And in the roadmap approved by the HAGF, a national consultations on this framework is set to hold sometime in Q2. The role the FMOJ is playing is in line with the provisions of the Cybercrimes Act, like I mentioned earlier, which empowers the office of the HAGF to ensure the laws are strengthened and enhanced to conform with regional and international standards, to maintain international cooperation that is needed, to deal with cybercrimes and promote cybersecurity, and then to also effectively prosecute these matters when they arise. As I conclude, what are some of the lessons that we've learned from this entire process? Our strength as a nation lies in collaboration. We cannot keep working in silos and expect to move forward. It's important that we take on a whole of government and a whole of society approach, because that's the only way that we together will stand strong and make waves, have successes recorded. Cybercrimes cannot be dealt with effectively in silos. The involvement of relevant stakeholders such as the government, in fact, even in the government, you need to have the executive, the legislative, and the judiciary have conversations, because it's important that as the policy is being made, those who are going to translate that policy into law understand what it's about. And those who are going to interpret it are the judiciary. So they also need to understand. You don't expect them to magically just understand it. So we need to keep having conversations around it. So you would even understand that when cyber capacity building is taking place, these days you bring in the investigators, the prosecutors, and the judges together, because there's need for those conversations, so that even the prosecutors can guide the investigators to get the evidence that will be admissible before the judges. So you can't have it. You can't keep working in silos, you know? And so you need all these critical sectors involved. You need the industry. Who are those who own the infrastructure? You're talking about protection of national information infrastructure. You're talking about service providers. Who are they? It's the industry, it's the private sector. You know, so you need to have them, you need to have everyone seated together. Civil society, all of society is important. Who are those having this advocacy? It's Paradigm Initiative. It's not a government arm, but then they have created this platform, and that's why a number of us from the government agencies are seated together, and we will be able to have discussions that would foster, that would make progress. So that's very important, like I said. We need, again, we can never overemphasize the need for a whole of government and a whole of society approach. And it just does not need to just be said, but it needs to be seen as a holistic approach that is being taken. Secondly, cyber laws need to evolve to address emerging trends. There is a need for technology neutral approach in the drafting of these laws. You know, so even at the Federal Ministry of Justice, for example, it's not important. It's not okay that you just have someone just come up with a document or just come up with the ideas. There are people who are skilled draftsmen who are able to bring out the thoughts. We have a legal drafting department. So there are people who are able to bring out those thoughts and put them properly in the form that they are expected to be. So it's not even okay that even at our ministry levels, we go in units and all of that. We still need to be seen that is also holistic, even at organizational level. So we need to be able to have laws that are dynamic, laws that are easily adaptable. I mentioned earlier that a number of things now today, the talk is talking about, it's all about AI, it's talking about blockchain, we're talking about ransomware. So a lot of these things were not topical as at the time that our law came into being in 2015. And yeah, I can't even say that the 2024 Amendment 1 also really took note of that. So those are some of the things that we should be able to capture. Lastly, a holistic approach is needed. We have cyber-enabled and cyber-dependent crimes. Some traditional crimes are already covered under existing laws, and there's a need to find a place to harmonize all of them. You know, it's not important. It's not okay that you have. I think when we was talking earlier, he spoke about online child protection. You have laws. You have laws that provide for some of these things. So why not find a way to harmonize these laws that are already existing rather than create more? It is not a need for more laws, but for the ones that we have to be enhanced, to be strengthened, and become implementable, if there's a word like that. Permit me, in case there's none, add it to my new vocabulary. So we do not lack it, but the strength and the enhancements that is needed is what we need to give to boost these laws, such that when it comes to their implementation, it will be made a lot easier. So there are a lot of laws that are existing that need to be harmonized, the ones that are traditional crimes, which are only being aided by the use of computer systems. How do we strengthen all of these such that we help the presidency also cut governance costs? So on this note, I would like to say a very big thank you for this opportunity. I hope you were not bored by my long talk. We're available for further discussions if possible. Thank you so much.
Now we're moving on to the panel discussion, analysis of the Cybercrimes Amendments Act, and we'll be inviting our panelists to join us on stage in person of Abraham. Sorry, I don't want to mispronounce that name, but in person of Abraham Dangman. Thank you, from API, the Associate Director for API. We'll also be inviting to stage here Bukola Adesokon from Tech Hive Advisory. All right. And then we'll be inviting the Executive Director of Paradigm Initiative in person of Benga Chesson to also join the panel on stage here. Finally, to moderate this session, we'll be inviting our very own Khadija El Usman from Paradigm Initiative to join us on stage here to moderate this session.
So I want to start by thanking the Ministry of Justice for, first of all, honoring our invitation, for coming to speak to us about the act itself, how it came about, the strides, and everything in between. Thank you very much for the time that you took to take us through that. So this panel is, I guess, to break it down a bit more. So we've heard from the ministry and their thoughts on it. For those in civil society especially, you would know that we've been clamoring a lot for an amendment. Heck, the ministry itself has been working towards an amendment for a while. And then one popped up. So tell me, Bukola, what are your general thoughts on the popped up amendment?
I like that you used the word popped up. I would first introduce myself. My name is Bukola Deshokon. I am an analyst at Tech Hive Advisory, and Tech Hive is basically a technology consulting firm. We do a number of things, but you would readily find us at the intersection of law, business, and technology, right? So let me just head on to what she had asked. The popped up amendments. Well, I would say that it's a welcome development, yes, and it has amended some of our worries and concerns generally around the act. But I would say that it has not answered all of our problems. I mean, there's still a lot that we need to correct in the act. And I think that's why we're here today, to lend our voice to that discussion. I don't want to start getting deep into it, right? But there are a number of sections, and I will stick first only to the amended sections that they had provided. I would speak first to the CERT. The amendment still does not cover the worries that we had as an organization. We had spotted before that it would have been better to have CERT as an independent organization stand on its own and not have to answer to any other body, because then it makes it easier to implement all of these things. It makes it easier to operate better and have a broader implementation of the act itself. So now limiting it to be under be an organization under UNSA for starters it still limits the powers. It cannot function properly. It cannot actualize. It cannot read it cannot read to the implementation of the act and ensure that all the scopes are like covered. It's still very, very limited. So that's something that we first need to talk about. I would also speak to section 24, the amended part of section 24, which is something that has been deliberated a lot. Everybody has come to say, oh, this is limiting. It affects journalists' rights, freedom of speech. There's a lot of debate around it, right? And then the amendment came to say, it now changed the words and said, anything he knows to be false for the purpose of causing a breakdown of law. It's still a lot. It still doesn't cover what we need. It doesn't address the concerns that we have. For instance, I'm going to say that uh, while it has changed the language and everything, and there's still questions as to how it guarantees freedom of expression. So you said, okay, where it causes a breakdown of law, to what extent do we know that whatever this person, the individual would say would cause a breakdown of law, or to what extent is this threat to life? We have to have basic definitions of these terms that they have used. Even though they have changed the language to these terms, it doesn't allay the fears of journalists, for instance, because there's this fear, these words can still be used by political political parties and governmental agencies, and say, oh, this thing you did still constitutes an act of breakdown of law, or it still constitutes threats to life. So we need these terms to be properly defined to understand the scope of how this can be used. Then we can have journalists speak freely. We can have everybody express their minds freely. This is still very limiting. I think this is something that needs to be addressed.
Yeah. So, like Bukola said, there has been a lot around Section 24. Do you have any thoughts there, and to other parts of the Act?
I definitely have thoughts about Section 24. It's interesting that we now have Cybercrimes Act 2024. Just like you said, it popped up. The conversation was happening. There was a public hearing. We protested because the public hearing was quite interesting. The usual public hearing, you get the adverts today, you show up tomorrow. And we were blocked from getting access to the National Assembly, which is what we have communicated, by the way. And I'm saying this publicly because the National Assembly needs to get a message. It's the people's building. Keeping people out of the people's building is an oxymoron. But that to the process of the Cybercrime Act. And process is important. The outcome may be good. It's much better. Section 24 is much better now. Even though we know that what was changed was 1A and 1B. 1C is still there. 1D, 1E, all of those words like bully that need to be defined. But at least, thankfully, annoying words like insult, like annoyance, and other words that made no sense in a cybercrime law, which basically was arrest journalists law, to be honest. Which cyber criminal was, how many cyber criminals were punished with the Cybercrime Act of 2015 versus how many journalists were jailed? So in a way, it was the punish journalists law. Section 24 has not been amended. A step has been taken, but the process is a problem. And I think it's really important because before we got here, we went to court. The case is now at the Supreme Court saying that Section 24 is illegal. The Supreme Court, yes, we know the wheels of justice grind slowly. So maybe after I die, maybe we'll get a date. Don't worry, I'm not dying soon. I know for sure, for a fact. There's too much to enjoy. Now, the reality is that Section 24 and Section 38. And I think it's important to mention Section 38 because it gives sweeping powers to security agencies to literally take. Security agencies already have powers that are not ascribed to them. Section 38 made it worse. Thankfully, it's not been amended also. Section 38 now includes the Nigeria Data Protection Act compliance, which is great. But I have worries about that because last week, the NDPC, 2 weeks ago, the NDPC was offered on a platter of gold an opportunity to enforce action against NIMS's terrible loss of our data. NDPC promised 7 days. 7 days later, they released a statement. I'm sure they're here. Okay, they're here, but it's fine. I'm sure you've heard me say this to you already, and I'm saying it publicly, and I'll say it again tomorrow, and I'll say that at our meeting later today, that you missed a golden opportunity The opportunity was to send a message to say, when you do the wrong thing with the data of Nigerians, you will be punished. Because we have a major data abuse impunity scenario in Nigeria. INEC has lost data. NCC has lost data. We can keep naming the names of, banks will soon lose data. Because it will happen. Why would it happen? Because none of it has been, punished. So it's great that we now have this amendment, but I think three things for me that are concerning. One thing that is great is that we have the amendment. At least I've said something nice. It's great. But one thing, number one is the process. We need to do better at the process. I'm glad to hear Justice talk about whole of government approach, but we don't have cooperation in government just yet. I know how surprising it was for some government agencies. In fact, without naming names, certain government institutions that should be aware got this document from Paradigm Initiative. How more annoying can it be? And you're in the same government. So, you need to talk to each other a bit more. And I'm glad you're talking to each other. And I'm glad, we'll continue to provide platforms to do that. I see Khadija's mic going up, so I'll shut up.
Thank you. We're talking gaps. I know you would love to hit the nail on a gap or two, but we also are looking towards recommendations. One of the good things is that we are hoping to take our deliberations from here. Okay, so I was saying that one of the good things is that we're hoping to take everything that we've discussed here back to the legislature. They were heavily invited and followed up with. Whatever you think you saw from my team, the National Assembly saw worse. Alas. But anyway, getting back to you, Abra. Recommendations? You can touch on a gap or two. Whatever is itchy.
Okay, well, I would like to begin by saying that it's commendable that can you hear me, please? Yes, so I would like to begin by saying that it's commendable that the act is being reviewed. Again, there is room for a lot more improvement. For example, Section 24, which has been spoken about extensively. Again, as the speaker who introduced this session spoke, she mentioned something about the need for tech neutrality because cybercrimes keep evolving daily. There are several kinds of cybercrimes as technologies evolve. Even pretty recently, there's now consideration or research around the possibility or the potential for harm where parents share information about their children online, their pictures and all of that. And the research says that by 2030, that kind of information can be farmed and used for identity theft, So that's like a cyber threat even to children, for example. So it's important that the amendment process also considers the need to move beyond just highlighting or punishing specific cyber crimes to also taking into consideration the need for highlighting potential crimes or potential cyber threats in the future. Another thing that I think is also relevant is the need to designate critical national information infrastructure. So we know that the Act as it is considers the need for the protection of critical national information infrastructure. And the problem is that there are no specific networks or specific framework that have been so designated. We find that increasingly critical infrastructure is being attacked. I think in 2030, majority of the cyber threats, at least according to the repository documented by, I think it's the European repository, which is an open access database, they found that majority of the threats that were as a result of cyber attacks were critical infrastructure. And when it comes to organizations, for example, we ransomware attacks on the database of companies. Most of the time, the attack results in financial loss, financial harm, which might amount to reputational damage. But when it comes to a country, sometimes the potential can be a threat to national security, which is really critical. So I believe it's also important for the amendment to also consider actually designating what we consider or what we know as CNII. So I think there is room for a lot more improvement, generally speaking.
Thank you. So we have wonderful. We have 10 more minutes on this panel before we then come to everybody else in the room. We want to hear your thoughts. If you have any questions for experts, if you have any questions for those in the room, not yet, we're not there yet. I saw hands up. We're not there yet. If you have any questions or contributions, thoughts that you definitely want us to take back to the National Assembly, that would be your time to speak. So I just want to ask our panelists if they have any more recommendations, thoughts that you want to share with the room before we close this out.
I see that we've been speaking more on gaps. But let's also commend the amendment for the Section 21 amendment that now provides for 72 hours reporting time and sectoral sets, organizations, sectoral parts per set. So this makes for a wider reach and faster reach, enhanced coordination, and putting CERT at a faster timeline to resolve these issues and observe any other issues that come up. So going back to
recommendations.
Okay.
But I appreciate that you commended it because it's better. Not there yet, but better.
Yes, that's something we could commend. So further recommendations, speaking on this part that I've also commended, would be to sort of like put out a procedure or a map to say, okay, this is how you can report these observations or situations to CERT. Even though we're putting out sectorial parts now and all of that, we should have like a procedure that says, oh, you can report this way, you can use this website, and just something that makes it easy for people to reach and report these situations. I think that's, I don't want to speak too much on.
I mean, mine is a simple process recommendation. I want to endorse the whole of government approach, that the Minister of Justice is recommending. But before I say that, there are very serious concerns about CERT reporting to the National Security Advisor. The office of the NSA is a lot more political than it should be, and that means that CERT literally can then become literally hired guns against activists and political opponents. That is a major concern. But when we get to the next amendment, we'll talk more, about that. For now, we'll still use the court. But the process, we already have memos that were sent in that were not considered, including memos from government institutions, by the way. And this is critical. So a whole of government approach means that we strongly recommend the Attorney General has a seat on the table. Other ministries have seats on the table. Other agencies have seats on the table alongside the NSA. We strongly recommend that you exchange notes again. Look at some of the memos you have sent in. The process has been, fast forwarded, and this is now over. But we're recommending another, as soon as possible, another amendment. We have a judgment from the ECOWAS court that clearly states what needs to be done with this act as it was. We missed an opportunity to address all of those because it's like you're hungry, then you quickly, drink, eat something that will make you more hungry instead of just eating a proper meal. So I recommend that we start with that, a whole of government approach, all of the government institutions sit together and then have a conversation with their twin, which is the National Assembly, and let the National Assembly know that thank you very much for what you have started, but this is just the beginning of a process. So that when you are ready, you can then invite other stakeholders, civil society, private sector, academia, media, where we are ready. We've written the memos already. We're ready to join you in the conversation. But first of all, we need to be sure that there is we know there's some friction, but there's always friction everywhere. But we want to be sure that friction does not produce heat that will consume everybody. And I'm sure that when that message is relayed to government institutions, they understand it. That friction, please, for the sake of Nigeria, who is in charge, who is not in charge, we'll leave that aside for now. But the recommendations that have been made, we have a standing, judgment on this law. We have an opportunity to address that, and we have recommendations that have been made. And one final thing, the simple request, and I think I've heard that repeated here today, definitions. One of the biggest problems with many of our new laws is definitions. So people then take a word, insult. A governor used the word insult to arrest somebody who Erisco Foods. Why on earth would you arrest someone for posting on Facebook using the cybercrime law? It's a shame. But that is what the law became in the hands of weak people who think they're powerful.
Yes, just to comment, it's really a wrap up of all that have been said here. While we commend some of the amendments that have been proposed and implemented, for example, the consideration for changing the name cyber crimes from crimes to cybersecurity, so that it's, encompasses a lot more. There's still room for a lot of amendments or a lot of changes. So yes, essentially, it's just so that I don't reiterate or repeat what had been said earlier, there's room for more improvement.
Thank you, Abra. Thank you, Benga. Thank you, Bukola. Please, can we give them a round of applause? I don't know about you, but between this session and the last one, I have learned so much. Someone saw me early this morning and asked me, "What are you coming here to teach us?" And I'm like, "Me? Teach? I'm here to learn." And I've taken in so much. But I know not everybody in this room is like me. We have experts, we have researchers, we have those who have been at the forefront of this advocacy journey. So now we're opening up the room for thoughts, comments, considerations, questions. I need a mic person, Paradigm Initiative. Please, thank you. Adeboye had his hand before this session started. So we start with Boye, then we come to you. And get
All right.
into the room. Yeah.
Thank you very much. So not really a question, maybe an observation. Benga spoke a bit to it about procedures. When I heard about the amendment to the Cybercrimes Act, I was worried. I was worried because, it was a good thing that it was amended. Some of the concerns we had was addressed, but I was worried about the process. And not just because of what happened at the National Assembly in terms of denying access to some of us who wanted to be at the public hearing. But when I looked at the amended act and I saw that on 27th of February, the clerk of the National Assembly signed it, and on 28th of February, the president signed it, that for me is a red flag. There was a time in this country that for any bill to become law, when it is sent to the president sends it to all relevant agencies to get feedback from them. So I think it's problematic that National Assembly can take a passed bill to the president and under 24 hours, the president will sign it. What that tells me is that the decision to sign it was already made. So it didn't matter what anybody thought about it. While it might have, resulted into something that we like, but let's think of the day they are going to come up with a bill that is not going to be in our interest. What will happen is that we'll wake up one morning and realize there is a new law that's going to affect us. Nobody will even know about it until it is signed. So my call to action is that I think we need to use whatever instrumentality that is available to query that process so that it doesn't become the modus operandi of passing laws in Nigeria. Because if nobody is speaking about it, it's going to happen many more times. And we don't need to wait until it results into passing a law that will mean that we cannot even cough in this country. So that's my intervention. Thank you.
Thank you, Adeboye.
Thank you very much. My name is Ayo Adebusoi, Nigerian Network of NGOs, Triple NGO. Thank you very much, Benga and the Paradigm Initiative team. I think there are a few things that come to mind. One is we'll need the act, this new popped up act. Please kindly share. Because those of us who are not in Abuja many things happen in Abuja that the rest of the country don't know about. Also the judgments, the ECOWAS judgment, please, if you can kindly share that as well, because that's significant for advocacy. And this section 24, the little I heard, and that's why we need the act, it still has a lot that your average policeman in the states, operational level, can act on and arrest anybody. Disrupting the peace or whatever, it can be used for anything. So I think it's something we should address. That what do we want? Okay, if we don't want this, let's even articulate what should be there, and let's have a common consensus about what we really want to be there, because something will be there with the Pandora's box is out. So what is it that we need to be there that will not have any room for ambiguity? And I think the last one is the issue of the cert. Again, we haven't heard about it. I mean, when INEC and the IRF had these problems, the attack, did they report to cert? Is there any track record of what they've been doing? Because we're just hearing of it in the law. How have they been actually acting in practice? Maybe you can enlighten us. Thank you.
Thank you. Okay. Yes, more hands. Calls to action, thoughts, comments, questions.
Good morning. My name is Kehinde Adebega, and I work with Human Rights Journalist Network. I was surprised when I heard the bill was amended and it was passed. Like everybody felt, even though we know what that process went through. There are one or two things that I did also want to mention. I don't know whether because I know the civic space, civil society have been doing a lot of advocacy, but I'm talking to the Office of the Attorney General, especially because they are custodians of this law. Is there a reciprocity of what exactly we have done with this law since 2015? Because that can really help us to know that how well we have done. Because, like, for instance, coming from the freedom of expression space, I can tell you that I hate that law. And you see even the police, and you begin to ask, who is supposed to even interpret this law? You see the police PR will say, you have come against Cybercrime Act. They will just put it on social media as if like that law is like a written law for them to gag everybody. So who is supposed to interpret this law? And another thing that beyond even the law is the process. Because before they start bringing up charges, you see a journalist or a citizen picked from Lagos and they are moved to Abuja because of Cybercrime Act. So I don't know whether the Office of Attorney General is really even talking about these abnormalities that is happening in the democracy, or is it a militarized democracy that we have? So thank you.
Thank you, Kehinde. So thank you for your thoughts. I wonder if the ministry wants.
Do I have your permission to speak?
No, I don't. I can't see you. I'm sorry. You gave a guidance, the mic.
There's a conspiracy for you not to see me.
I couldn't see you. Someone here had their hand up before you, but since you have the mic already.
Thank you very much. Good morning. My name is Edith Anuja. I work with the Media Rights Agenda. I was quite excited to hear the comments from the Federal Ministry of Justice. It was all very positive, but I think a far cry from the reality that we're used to in terms of practice. So I was wondering about a couple of things. One is whether we've really reflected on the manner in which the abuse of the Cybercrimes Act has cost it credibility. Boye talked in the beginning about how supportive, how excited we all were in the beginning about the passage of such a law. But as soon as it became law and it was now being abused, else having to do advocacy against a law that we had previously supported. And as Benga said, we actually had to go to court. And right now, that matter is depending at the Supreme Court. So I'm wondering whether the Federal Ministry of Justice, and you have the Chief Law Officer of the Federation heading that institution, who in practice should be the one advising all federal government agencies about all things legal. Yet, we've had a lot of agencies, law enforcement, intelligence, security, military, and all abusing this law. And we really didn't hear anything from the Attorney General or from the Ministry of Justice to ensure that this law retains its credibility. And indeed, I think it was being defended from that office when certain provisions of the law were challenged, including at the ECOWAS court. So I just want to urge that we reflect deeply that, because by supporting or condoning the abuse of the law, it lost its effectiveness. If you look at data over the years, you will find that there's been an increase in cybercrimes since the law came into effect, rather than decrease, because the law was not being used for the purpose for which it was passed. And this is something that if we are doing a whole of government approach, I think it's important that the Federal Ministry of Justice to other sister ministries, departments, and agencies of government. Otherwise, your efforts will continue to be in vain. We will not fight the real cybercrimes. We will be going after journalists, bloggers, just trying to hold government accountable. Thank you.
I do wonder if the reason why we see a focus on certain sections of the act is a thing of capacity. How many of us and law enforcement, etc., know what the technical aspects of the act even mean, actually interface with issues of cybersecurity beyond the insult, ill will, and all the other things that Section 24 mentioned. But that's just me.
Good morning, everyone. My name is Mojirayo Ogunlano. I am, a digital rights lawyer. And interestingly, I didn't want Mr. Edeton to go before me because I knew he was going to say everything I wanted to say. So, Mr. Ojo. I'm holding on to my laptop because I didn't see the amendments. I was just sent a copy. And looking at the part of that section 24 again, let's look at the old one. The old one says the criminalized online speech with the purpose of causing annoyance, inconvenience, danger, obstruction, insult, injury, criminal, intimidation, enmity, hatred, and so many like that. And then you now bring it down to any person, any person who knowingly or intentionally sends a message or other matter by means of computer systems or network that is pornographic or knows to be false for the purpose of causing a breakdown of law and order, posing a threat to life, or causing such message to be sent. And then I'm looking at the reality, as Mr. Ojo just mentioned, as a practicing lawyer. And just finding out that this is the new amendment, understand? And this is the field that, of course, I'm supposed to be very, very vast in. And then finding out also from Sheson that a lot of organizations were not even aware. I don't think in 2024 we should be passing any law that has to do with the internet space. And we're not involving organizations that are really invested in the internet space. Now, with not to bring low the work of beautiful lawyers in the Ministry of Justice, but I want to say that at most times you are the one prosecuting, you are the one going after people. You barely defend. When you defend, maybe because we put you there as, the neutral party in quotes, the chief law officer, for instance, AGF. So when you're having this kind of provision or we want to amend a particular law, I think it's important to involve legal practitioners, people who actually interface with, for instance, journalists or litigants who have suffered from laws like this. Because it doesn't make sense that you should have a law that we know. My litigation clerk spent 3 weeks at the police for just being at the wrong place at that wrong time. Should I put it at wrong time? So somebody goes into a place and steals 5 television. But my litigation clerk, because he's on
part-time, not full-time, is the cook for that particular bit, a governor's lodge or something. And then they pick them up and torture them. Terrible torture. So this, that is the reality of most Nigerians. Most Nigerians, you can get picked up and they would use this law and tell you very well, you know it to be false. And that is it. That's what police does. They harass you, they take it out. Even you as a lawyer, you cannot get anything out of them. They have now gotten into a practice where they go to a magistrate, not close to the police station itself. They get a remand order. When they get the remand order, they have the right to keep you for a longer time. And as you're walking in as a lawyer, telling them that, oh, I am here for this so person, they tell you, oh, lawyer, you are here. Go and fight fundamental rights. That is the reality for every Nigerian. The insolence, the impunity is very real. So we cannot play with laws like this. Because a journalist should, at no point in time, should feel that they cannot bring out information, for instance, that they cannot publish information that is relevant to us. So this, although the reality is that people are self-censoring, media is self-censoring now. No, it's not good for our democracy, really. Thank you very much.
Thank you.
So, well, I will just make an attempt. I don't promise to answer all questions. It will just be an attempt, and permit me however it is that you receive it. Okay, so about the repository, I can tell you that there's one, but one thing I can very clearly say is that I recall last year, the Federal Ministry of Justice was involved in an international conference which had to do with the second protocol, International Cooperation on Combating Cybercrimes, which was held in Morocco and organized by the Council of Europe. And we had this World Bank guys who were carrying out, I think they were doing some research or doing some publication on a toolkit. And one of the key things that they wanted to know was how far we had gone with Section 24. And about this time, we needed to really come back home and see what it is that we had done, you know. And this actually strengthened the approach that the Federal Ministry of Justice has taken. And I don't know how many of you were present at the national consultations, the first national consultations, but I know how much we tried. Just the same way that Khadija is saying that if you felt any impact from her team, what the National Assembly got was worse. We also tried so hard to get paradigm at the national consultations, and we failed. We didn't get you guys. Yes, because we tried as much as possible to get every sector involved. Letters were sent within and outside Abuja. And for those who were present, at least I know we had almost 200 people in attendance, which had to do with people both in the private, the CSOs, and even the government agencies. And we have that database to send out information even for the upcoming ones and to even widen it, just so that at the end of the day, it's our process. And whatever document is out of that, we will say we own it because you had a part to play. You had a comment to make, you know, and at the end of the day, we will be much more, what I call it, willing when it comes to the implementation part where you have your own role to play your own part. So I would just like to say that we're doing well. It may not be so commendable, but then I believe that we're on the right path, and that path is to see that whatever discussion it is that is necessary, because our own face internationally is very important. And whatever it is that will take the office of the Attorney General by the help of God to see that this works, you know, I believe that it will happen. And on the speaking with more agencies, it's such platforms, it's advocacy, it's engagements, and we're trying hard. Of course, we know government hasn't been so funded well. So funding is key, but then somehow we're finding support, and we're doing that. And like I said in my earlier comment, we're working towards having a national consultations in Q2, and it's important that everyone around the table attends when you get the information, please. Because it's there that at the end of the day, we'll adopt communiques, we're working with whatever it is that participants agreed. So please, make yourself available. One of the key parts of that presentation was, how do you support the process? You support the process by being a part of it. And this is how to be a part of it. Thank you very much.
But I also want to point one or two issues that I noticed within the act that I feel the ministry may be able to give us response for, particularly as it relates to the implementation of the acts. Just like he mentioned, there are two issues. First of all, I don't know, were we able to look at how the act and case law, I mean, case law is forms part of laws in Nigeria also, and particularly the provision he mentioned where people would be picked from different parts of the country to go and be tried on different offenses within the act. I know that is clearly, there's case law that clearly forbids that. I think there's a case of Ibori and Federal Republic of Nigeria, where that offenses must be tried where it emanates from. I think that has still not been amended. There are a lot of issues also regarding the Act enforcement and its relation with the Evidence Act. At the end of the day, the implementation of this Act or prosecution or defense would still boil down to the provisions of the Evidence Act. And there are a lot of provisions in I mean, even the definitions of computer in the Evidence Act, I don't think it suffices enough to cover for what the Act, the Cyber Act itself is saying. So these are areas that I don't think was reflected in the amendment that I think the ministry, perhaps if it was a more robust engagement, would have been able to take note of that. And also another issue is this issue of law enforcement agencies. The Act still does not specify the particular law enforcement agency that would take lead. I know we have, I mean, Nigeria's security space, we have an oversaturation of so many security agencies working on different or the same thing. I think it's good that the amendment should have taken note of perhaps providing expressly the law enforcement agencies that would oversee monitoring and compliance of this act. And there's also the issue of the act and other legal provisions like the BOFIA, that's the Bank and Other Financial Institutions Act. We also even have the VAP law, Violence Against Women, Persons Prohibition Act. I mean, there are provisions there that kind of intersect or should have been able to provide a clear distinction between provisions there. And then lastly, sorry, time is not on my side. And then lastly, also, the Act provides for the Attorney General to make rules and regulations supplementary to the Act. I don't think that has been done. Sometimes it's not just about the Act. We can make rules and regulations that can be able to provide a clear, clarify on some of the things that are in the act that can be clarity can, I mean, that we can get clarity on. So I think it would be good also for the ministry to look into making a rule or a regulation of the Cyber Crimes Act while we wait for a more robust amendment. Thank you.
All right. Good morning, everyone. My name is Joseph from Nina, Georgia, a policy firm. So I was looking at the amendment bit, and I saw that that's section 41, which says ensure that all public and private organizations integrate and route their internet and data traffic to the sectorial, that is sectorial security operation centers, thereby protecting the national cyberspace. I wanted to get clarity because I didn't hear anything. I wanted to get clarity. How does that sit with the data protection itself? Yeah, thank you.
Okay, thanks for mentioning that. And I think there are two things that need to be done. One is that there is already a problem of lack of cooperation around what NIMS is supposed to coordinate. So there's a presidential directive that all agencies collecting biometric data should work together. That hasn't happened. And my fear is that what you've raised may complicate that. But I think it's a perfect storm that we can take advantage of. Let's not waste this opportunity. Now that we have two big problems, then let's see them together. And on one hand, make sure that the presidential directive, is worked on. And on the second hand, make sure that we're not talking about another level of integration, which can lead to another committee being set up that will then work in parallel. But, thanks for, raising that, because it speaks again to an existing problem. So we now have two problems.
Okay, nothing to add. Thank you very much to our panelists. Thank you for being here. Thank you for honoring the invite. I think all of them flew into Abuja. Thank you very much. We truly, truly appreciate your openness. We appreciate your partnership with us over the years, being here, answering the questions, and being open to the feedback that we hope to send to you in a more comprehensive format. Recognizing other agencies of government in the room, NITA, NCC, NDPC, NHRC. And now we're going to break into tea, and then we'll speak about another very interesting upcoming bill called the Online Harms Bill.
NITA approved a partnership with Advocacy for Policy and Innovation, API, whom I'm representing here, to develop this bill. And the general purpose of the bill is looking at the protection of Nigerians online. We realize that there are a lot of, as technologies evolve, the kinds of risks or harms faced by users online have been evolving. And so the general idea is to centralize OHP. When I say OHP, I mean online harms protection, to centralize OHP to ensure that Nigerians are adequately protected. Lillian. Now, these are some of the key considerations for the development of the bill. This time, NITA would like to do things differently. And so one of the key things that has been emphasized in the process so far is the implementation of a stakeholder-led process. Because we are looking at following a ground-up approach instead of an approach where somebody at the top just develops an instrument or a framework and brings it on such that there's ownership from the bottom up. So our process so far has been a three-tier approach where there are 3 levels. We have the steering team or the steering committee that comprises key stakeholders that are relevant to online harms protection. So experts in the field, legal practitioners, civil society organizations. For example, Paradigm Initiative, I've mentioned earlier, they are part of the steering committee. There are other civil society organizations that are part of the process as well. At the second level, we have a secretariat, which comprises key relevant people from some of these organizations. And the essence of the secretariat is to take back whatever feedback that the steering team has given and implement them in terms of developing documents, doing some research that the first level stakeholders, which is the steering team, have suggested to us. And then the third level has to do with some sort of breakout team, because in the process, where there needs to be some focused research on some key areas that has to do with online harms protection, the steering team has been broken down to experts in those specific fields to handle those types of research. So that has to do with the third level. Now, another key consideration is the fact that the key stakeholders involved at this level are looking at a process that is citizen focused and that centralizes Nigerians at the middle. So we're looking at a process that is focused on protecting the Nigerian, including children, from online harms. Another key consideration is an adaptive framework. Now, we know that online harms keep evolving as technologies evolve. Currently, there are a myriad of online harms, from misinformation, disinformation. We have there's the potential for even algorithms by platforms to create bias and cause some sort of discrimination for communities or individuals online. So there are different types of online harms. We are looking at a framework that considers current online harms as present today and also looks at potential harms that could come up in the future. That's the essence of this bill. So we're looking at what kind of framework would accommodate for what we currently have and what could potentially happen in the future. We're also looking at, or we are also prioritizing a rights-based approach, an approach that considers that there's a need to balance online harms protection and also balance human rights, because we find that for something like content moderation, for example, which has been considered as a way to protect users online in their dealings online. Sometimes it can be used to stifle free speech. Sometimes it can be used to the advantage of people with ulterior motives. So one of the key considerations is the fact that we have to consider the need to ensure that the rights of Nigerians are secured while they are also being protected from online harms. Now, in trying to do this, one of the key things that we're doing is working on the development of a white paper. And this bill is going to be one of the bills that for the first time in a long time, there's going to be development of that document, a white paper that everybody would have access to eventually. We're currently in the process of developing it. But once the second draft is ready, it's going to be published, where a larger range of stakeholders can look through and also give their feedback, which is another reason why we're grateful for this engagement, because we're hoping that we can also get feedback from everybody on how we can better the process. So currently we're working on the white paper, but some of the key considerations on the white paper and also to be addressed on the bill is, one, the type of framework. So we're looking at what kind of framework would accommodate current online harms now and also account for future online harms, considering the evolving nature of the tech space or the evolving nature of harms currently. So that's one key consideration that's being deliberated upon by members of the steering team, as well as something that's being considered in the white paper, because we're looking at a framework that is adaptive. So what type of framework do we consider? That's a key question that under consideration. Another key issue under consideration is trying to balance content moderation and the need for online harms protection. In fact, as Boye said in his speech to open this engagement, initially it was titled Digital Rights and Content Moderation Bill. But upon deliberation with the steering team, we found that, and especially considering precedents too, we found that sometimes content moderation, although it is a tool used to handle online engagement, because online, most of the content on there is user generated. So it's difficult to really control the kind of content put on there. Most of the time you have to regulate after the fact, after the person has posted the picture, posted the image and all of that. So content moderation is used as a tool to handle that. We also find that sometimes it could also be used to stifle dissident voices. It could be used as a tool by people with ulterior motives to do their bidding. So this process is also trying to balance how do we ensure that content moderation being used as a tool works for this purpose. How do we balance that with the need to also protect online harms, which is a key consideration in the steering team and which is being considered in the white paper as well. We also, as I highlighted earlier, the need for a rights-based framework, which really relates to point 2 over there. How do we ensure that the rights of the individuals are preserved? And again, we also have to consider the platforms where Nigerians interact online. How far or to what extent do they have liability, over the kind of content? How do we measure this? For example, in the first draft of the white paper, one of the suggestions was, okay, maybe we should use a duty of care approach, where we say the platforms have a duty of care to their users and ensure that their users are adequately protected as they interact on the platform. This is something that was considered, but of course we got feedback from the steering committee as well that if this is something that should be considered, we need to adequately define it, which is another thing that this process is really taking into consideration the fact that we need to be clear on key terms, on key phrases and all of that. So what is duty of care? And considering that the general relationship of duty of care that we are used to has to do with perhaps the duty of care a patient has to, a doctor has to his patient, how do we now implement that kind of concept in the relationship that an online user, a platform has with an online user? So this is another consideration, that we're looking at. And another one is the implementation mechanism, right? So we are looking at, say this, we've agreed on a framework to ensure that Nigerians are protected from online harms, the different types of online harms, both currently, both as we have currently and in the future. What will the implementation framework be like? And of course, we realize that perhaps maybe we need to centralize implementation with an agency, but the steering team has indicated that we need to consider the fact that we probably do not need another agency, to develop another agency to oversee implementation. So in that case, what do we do? What are the options that we have? And that's something that is currently being deliberated upon. What options are there in consideration? And another thing too is, if we consider a framework for implementation, how is the whole process going to be funded, right? If we consider a government agency, we all know he who pays the piper dictates the tune, so that might also create a bias and problems for implementation, which will affect the purpose of the online harms protection. So what do we do about that? Again, what are the mechanisms for handling harmful content, the different types of harmful content? And of course, even here, we know that there are several stakeholders. There are there are the platforms, there are the users, and different categories of users. So this is something that's also currently being considered by the steering committee. We also have the question of what online harms protection means for different stakeholders. As I said earlier, of course, we have several classes of people who use the internet. We have children, we have adults. Who has responsibility for what? In the case of the platforms, of course, they might have responsibility for, to an extent, the kinds of content that they're allowed to. But to what extent do we responsible for the kinds of harmful content that appear on their platforms, considering that the users also have a responsibility for civil conduct online? And in the case of children, parents also have responsibility to ensure that their children don't, use the online space. They have more access to restricting usage in that sense. So what do we do? And that's one key thing that's also currently being considered. And of course, one key thing that has been reiterated by the steering team so far is the need to ensure that all terms are clarified. So currently, the current status of things now is that we are of course we're undergoing the process of stakeholder engagement, which is part of the reasons why this is here. We're here too, because of course we're all stakeholders in this, and to be interesting to find out your thoughts on some of the key components and your recommendations and suggestions. The purpose is that this is still at the beginning, at the infant phase. So when you come up with your recommendations, it's easier to impute, to deliberate upon, so that we'll come up with a robust framework. And the white paper draft is being developed. Now, the first draft has been developed, and some of the issues that I highlighted earlier have been included. But the process is such that it has to be reviewed internally by members of the steering team. And so once the feedback from the first draft is implemented, the second draft is going to be completed and is going to be published for the public to take a look and weigh in on some of the key key recommendation, which is the third step, steering team review and feedback. Now, once the white paper is finalized, it will be published, and we have a plan to work on a workshop that will aggregate all the feedback into the development process. So essentially, that's what the I can see somebody itching for a question, but yes, essentially that's essentially what it's about. I'm looking forward to your comments, your feedback. Thank you. Some people have questions or comments. I think I see a hand at the back. I also have some members of the steering team here, if they could also weigh in.
Hello. Okay. You mentioned that it's a first draft. Can we have access to that?
It's still in the draft phase. Yes, it's still in draft. You are going to have access. The plan is, upon first engagement with the steering team, they gave their feedback on possible options for what the framework should look like. So we're deliberating what should this framework look like, right? And then, of course, it's the secretariat went back to map out a draft, a white paper, highlighting what the general intention is around the online harms protection conversation based upon what the steering has said. Right now, we are working on implementing. After they have currently they reviewed the first draft, or they are even in the process of reviewing because it's an open document that's available to them. Now the plan is that while we are imputing that, the members of the secretariat, right, that's the second level, while they are imputing this, they impute it and give it back to the steering to look again, and then it will be published. So it's really at the draft phase.
So that means we don't have a document that we can have input on yet.
Not yet.
Okay. So
not yet, but incoming.
Okay, so is there a timeline so we know when we are expecting this, that?
Well, we are hoping that in the next few weeks we'll be done with the development of the second draft. That's the hope.
Thank you for the excellent presentation. I listened closely and I was following through everything you mentioned. But I just wanted to comment on something that was mentioned earlier in the first presentation from the person from Federal Ministry of Justice. I think this is a very, very good innovation. I think it's beautiful because the online harms bill is very handy, especially as these issues are very much recurrent in the Nigerian cyberspace now. But I also think that we do not exactly need a separate legislation on this. I think it's good we add or most of these provisions here to either the Cyber Crimes Act or the VAP law, or the VAP Act, sorry. I think most of the provisions there can also fit into either of these two acts, and it will be well taken care of. Like she mentioned, we are having so many legislations, and many times when it comes to prosecution, it becomes an issue because you find out that many of those provisions are in different acts or different laws, and then you will not know which one to even charge an offender, and many of the times they have different penalties. So maybe let's say, for instance, in the VAP law, the penalty is 8 years imprisonment with option of fine. Maybe in this online harms bill, it may be, let's say, 14 years. So many times prosecution would now be, confused on which one. So when they go to the one with the lesser punishment, it is called foul because it seems as though the prosecution are trying to land on a softer plane. I think most of these provisions can be incorporated in either of the two laws or other acts that we can look at. Thank you.
Okay, thank you so much. Your name? Okay, Comfort Usman, let me just speak. Thank you so much. That makes a lot of sense. And that has been, or that is one of the feedback we initially got from some members of the steering committee. Do we need another regulation? You know, but not but, just to highlight that one of the key considerations, that we're looking at is perhaps the need to have a framework or a regulation that centralizes online harms protection. Now, here's what I mean. Number one, the focus is to ensure the protection of Nigerians. So it's almost like a move away from just punishing or saying, if you do this, this is the punishment or this is the penalty. And that's why we're thinking framework based. So considering that there's an evolution currently as technologies evolve, there are several harms that we find. What kind of framework do we come up with that can ensure that we can guarantee the protection of Nigerian citizens, even for online threats that we currently have now and future online threats? And that also has to do with ensuring or mandating that some of the stakeholders are proactive enough to respond to evolving threats, anticipated threats. So it's the general idea is to go beyond just punishing when it happens, to also have a stance or have a position such that when it happens, the general idea is that there's a reactionary approach when it comes to regulation as it relates with technology. So we wait, the technology happens, and then we react to it. But the general idea is that while we ensure that, okay, there might be some penalties in some instances, how do we also balance that and ensure that there is already a structure or there is already a position? Time. Okay. Yes, there is already a position such that when these evolving threats occur or when it is anticipated, we know that we're not going to be scrambling for, how to act. That's another key consideration.
All right. So I work for the Center for Journalism, Innovation and Development. I think my first response would be, it's always difficult to give a review or a feedback if you're not sharing a draft, right? So right now, you've only, tried giving us an overview, and it's difficult to know exactly what the content of this proposed online protection, you said? Online arms protection. And I'm wondering whether the new provisions that we're going to have under the online arms protection cannot be made provisions for, under other existing laws. I see that you're making a very significant effort to justify the need for this new law. But I think for my organization, we would wait until we see a draft, and then we can give a feedback. But where you mentioned content moderation versus online arms, I would say that for journalists, for example, I mean, we're beginning to see instances where a lot of the work that journalists do, investigative reporting, or just their handles on Facebook, on Twitter, are brought down or banned, because certain bots or certain individuals make it their business to just report those handles, heavily. And I'm then wondering, so when you say on content moderation now, who are you thinking of, or what institutions are you thinking of? Is it the government now thinking online moderation or content moderation, or you are thinking about the platforms? Because where it concerns content moderation, it is the platform that are mostly culpable. in that sense. So you're thinking Twitter, X, you're thinking Facebook, or maybe TikTok, or what mostly known now is Facebook and maybe X. So do we have a framework that allows us, even as a nation, to hold the platforms accountable? Under what framework are we thinking about that? And I'm asking these questions based on what we know that has happened in a place like Canada, in a place like Australia. Recently, when the news publishers and the government of Canada approached Google and Meta, and then they were talking about a need for Facebook, a need for Google to compensate news publishers and newsrooms for their contents that appear online. What Google and Facebook did was to yank off all news platform from Google and from Facebook, and even the government of Canada could not do anything about that. So when you said content moderation, I'm really curious to hear how we're thinking about this. How we're thinking about platform accountability. Who is on the side of holding who accountable? It will really be more educating if time allows you to speak more about it.
Hi, everyone. Good afternoon. So we would like to know the number of Muslims in the house to help us with lunch arrangement. So when I pass the mic, I'm going to be going around. When you see me at your table, just inform me so we can pack your lunch. Thank you.
Thank you very much for highlighting that. And that's one of the key considerations that we're looking at. Because even when it comes to harmful content, there's also harmful algorithms, that sometimes they are trained based on several responses that can rank some of the content online below. And that has an implication for free speech and freedom of expression. So that's why one of the considerations and one of the recommendations made by the steering members was the need to look at all the kinds of possible harmful, potentially harmful harms online that we have now, and what kinds of framework can be done about it. And that what I was trying to highlight there was, initially the thinking was digital rights and online harms protection, but upon engagement with the steering members, they highlighted that you can't focus on content moderation, and that was where the focus shifted to online harms protection. So that's one of the key things that's being considered.
Good afternoon, everyone. I'm Lee Abwe from the Cybercrimes Unit, Ministry of Justice. I would like to commend Comfort Usman for her comments that she made earlier on. And I have just two questions. How has the Attorney General of the Federation been taken along? How has it been carried along in this process? That's one. Two, what's the composition of the steering committee? I think it's important for all of us here to know. And I just want to draw your attention again, because you mentioned that the HAMS bill was for the protection, and not just for punitive measures. The Cybercrimes Act is for the prohibition and the prevention of cyber offenses. Now, we've been carried along. Well, the Federal Ministry of Justice it's been a long journey. I don't know if you caught some of the things that Madam Jamila spoke about earlier on when she was talking, but it's been a long journey to amending the Cybercrimes Act to make it inclusive, to make use of a holistic approach where different stakeholders are brought on board. Now, that's important so that in situations where this other group has this idea of, why not include this, why not include that, everybody's able to voice, their own opinions so that everything can be captured and then put down in a robust legal framework in case it wasn't there before. Now, I just want to say again, the Cybercrimes Act actually is for the protection, and it's not just for punitive measures. It is for the protection, and in case there are some provisions that are, there are gaps in the current act. This is why we have this process going on. This is why we're trying to take everybody on board, so that that protection is wide enough. I also echo what she mentioned, that I'm not of the opinion that it should be separated. Yeah, thank you.
My name is Abdullahi Aliyu. I work with the National Information Technology Development Agency, and I'm part of the Secretariat for the Online Harms Protection Bill. So what was proposed this morning is just an idea of what we're looking at, right? And that is why we're receiving inputs. I think unless you have a document before you, honestly, it will be very difficult to make contributions, or let me say tangible contributions. What I would say in response to the questions that were asked is that, for one, the moment I hear cybercrime, as a citizen, I would think, okay, this is more of addressing the criminality in the cyberspace. If we merge them together, if you look at online harms, we have content moderation that deals with legal content, which you don't touch on social media. You have to let it because it's legal. Then you have the harmful content, and you have under harmful content, you have like misinformation, disinformation. There is no way you can combine this or juggle it with criminal provisions, because the moment you do that, the citizens will automatically start fearing whatever you do or whatever your document is saying. I will elaborate on that briefly. So if you look at what is obtainable in the United Kingdom and other places around the world, in the EU, you would see that online harm specifically is addressed separately from cybercrime. If you want to combine them together, you have to change the name of the Cybercrimes Act to say cyber governance, for example. So if you say cyber governance, that is more harmoniously addressing the issue instead of saying cybercrimes, and then you carry or you bring content moderation such as misinformation and disinformation, which just require maybe fact-checking and more of a co-regulatory approach with the online platforms. So if you're doing an online harms protection bill, you will need input from civil society organizations, from the platforms themselves. Yes, media, yes, and data scientists. So I think it's a whole concept on its own that should be addressed more independently. If we don't give it the respect it deserves, that is why we will continue having situations whereby we have children on TikTok and we don't know what to do because we're focusing on cybercrime. So how do we address some of these issues, the nuances around online harms? This is just a summary. With respect to the question on informing the Attorney General of the Federation, we believe we need to have a document first. One thing for sure is that whatever we do, we make sure the composition of the stakeholders first. We have the likes of NCC, NBC, NITDA, API, Paradigm Initiative, Tech Hive. There are a lot of stakeholders. It's a small niche committee for now, which will be expanded. But definitely at some point, the moment we have a draft document, we will have to write to the Attorney General's office because we think it will be a good use of his time if we have a document that he can actually see, review, and provide input on. And remember, before this becomes a bill, it has to be taken to the Attorney General's desk and he has to approve of it. And stakeholders as well that are in this room and the wider stakeholders have to agree before we can continue this deliberation. So thank you so much. This is just a summary.
The stage at which this work is, it's difficult to even conclude what is going to be yet, because it's still a white paper, it's still a conversation, and part of that conversation is also to determine what is most appropriate. So that's why the feedback is important, but just to say that it is too early to even say that, oh, this is what you are doing, because and I think the essence of the consultation is also to be able to, come to a conclusion of what exactly should we do as a nation, as a people, as a constituent. So The feedback are welcome, they are great. Let's keep them coming, but trust me, nothing has been determined yet. It's still an ongoing conversation.
Okay, so my name is Ngozi Okpayokoro and I'm representing the disability community. And it's very obvious that persons with disability is always a last thought. So we have about 15% of the country's population who are persons with disability. And the online space is a space where we actually use very well. Like there's a popular saying that technology makes things possible for persons with disability. So when we're talking about the online harm protection, it's very important for persons with disabilities to be carried along. We have different clusters. I'm visually impaired, I'm partially sighted. So I really do not know what's happening in front, but I can hear your voices. So basically, how can we carry persons with disability along? You mentioned children, you mentioned parents. Persons with disability also should be carried along. So it would be very nice if in the development of the white paper bill, I'm not so sure if I got that right. In development of it, it's very important for persons with disability to be carried along. And there are a lot of clusters because persons with disability, we see that online space as a safe space for us to be able to relate very well. So really, persons with disability should be carried along in the bill. Thank you.
Thank you for the feedback.
It's a dialogue. Sorry. Adebumi Akimbo for the records. Okay, so I quickly checked the website. I was told NIDA is involved. Yeah, so I can know how to accuse you. So, one way or the other, what I saw is that you have certain information that other people may not have. You come across certain information that can actually blend into other information and assist in the formulations of policies. And based on that, that's what I saw from what the website looks like. That it's an intelligentsia.
You mean that website?
No. The API intelligence.org website.
Oh, okay.
Yeah. So based on that, I would agree that any time I have a challenge with any of the acts and I need more information, other particular sections of one act that cross carpet into another. Maybe, for example, the Cybercrime Act cross carpeting into the Child Online Act, and there is a particular link in between. You would have such an information, and I could make it, a useful tool to either correct, accommodate, or use as a legal person when it comes to law. So as a framework, that's been said. However, I would advise that if what I saw and what I've said is what we want to do, it's a good one because it wouldn't be affecting any other information as at today. I can tell you that because of what I've done right now. That's one. Two, is that the data protection area, you may have to correct some information, and that brings me to NIDA. NIDA, if it wants to be involved in this particular discussion, needs to understand certain things that allow the average Nigerian person to be a Nigerian when he's talking about either law or the guidelines that are associated with such laws. For example, your website is on the .org, not on the .org.ng. And for me, I feel bad because NIDA is part of you. NIDA should know better about that. Local content. We have an executive order 3 and 5 that says they should, uphold that particular one. That's the second thing. You may have to correct the contact on your data privacy that has a contact at api.org because api.org is another website entirely.
API is not part of NIDA, just to be clear.
Yes, I know. I'm just saying that since NIDA is a member of that committee, we don't know the content, but someone spoke that NIDA is part of the secretariat.
Committee.
So that's why I'm accusing them that they should have. So moving forward, the third final one is this, man. The ecosystem can accommodate more organizations coming into the fray. But it would be wrong if we don't get it right. And for me, I think you have gotten it right. You're asking for feedback. But I don't want people to think that this is another international organization coming to Nigeria, trying to get information and trying to use whatever data we have to become more popular. No, you're actually serious-minded people. So that's why I advise. We have to remove the api.org on your data privacy page. api.org would have been a very good name if that's the .ng, but right now api.org is another website that talks about NIG. NIG in the United States, American Petroleum Institute. So we don't want that confusion. Thank you.
Please let's put our hands together for Abra. She has been on the hot seat for so long. And just to reiterate, Abra works for API, which is a private entity actually. And API has only been asked by NIDA to lead this process. So API is more like the secretariat for this process. And a steering committee was also constituted that kind of involves a number of organizations working in the digital ecosystem. But I know that there are some of us that still have questions. Those questions will be taken. But the reason why we just need to break right now is that this next session is also talking about the same thing. So there's still an opportunity to give our feedback while we do that. And also, this session also represents some of the feedback that we have given to the Secretariat on the white paper that was published on the online harms protection bill, proposed online harms protection bill, the white paper basically, which is what we have for now. And this feedback represents some of the things we have sent, but some of them we have not shared with the Secretariat as well. I think the good thing is that since there are a lot of feedback also coming out from this room, we can also still collate that and share with the committee, with the Secretariat working on the white paper. So what I'm going to really do is to look at the white paper. Unfortunately, most of us here have not seen the white paper, but for some of us who are members of the committee, we have been privileged to see it, and that's why we could come up with some of this feedback. So this feedback is coming from that white paper, but also to just let you, to kind of make you aware of some of the conversation we are already having with the Secretariat regarding the proposal. The first thing is the fact that the duty of care as the central theme of the proposed bill is something that we have a lot of feedback for. And thankfully, Abra already spoke to me that they received feedback regarding that as well and some of the issues. Interestingly, NIDA has also raised, some issues regarding that. So I think it's not very common for civil society and government to agree on certain things, but I can assure you that some of the feedback on duty of care has come from NIDA actually, and I think that's impressive because in the first place, NIDA even commissioned this process, and it's great that they are also able to give that type of feedback. Please, the next slide. Okay, I have a lot of tests in my presentation, but I will try as much as possible not to bore you, to just speak to the issue and not to read through everything. So, the concept of the duty of care was first introduced in the UK online harms white paper. Many of us are probably aware that the UK has a similar law addressing online harms. I think it's called the Online Safety Act or something like that. Online Safety Act, yes. The process leading to that also, is similar to what we're trying to do in Nigeria now. There was a white paper. And when the UK white paper was released, it was built around this duty of care. So one of the feedback we have right now is also based on some of the feedback that was received when the UK published its own, white paper on online harms. So one thing about the duty of care is that it is a legal obligation that is owed by one person or entity to another to ensure that the latter, in situations where there is a degree of proximity between the two, does not suffer any reasonable foreseeable harm or loss as a result of the former's act or omission. Now, the legislation and the courts have shied away from establishing or recognizing the duty of care to prevent others from suffering harm caused by the acts of third parties, unless a person or organization has voluntarily assumed responsibility for their safety. As we would see later, one of the major points we're trying to bring out of here is to say that within the concept of the duty of care, it's a very tricky concept because it is very difficult to translate what that means, let's say in real life, into the online environment. And I will explain this further as we go further. Duties of care are almost exclusively found only in relation to physical spaces and largely in relation to risk of financial or physical harm. The duty of care originally proposed in the UK online harms white paper bore little resemblance to the established understanding of what a duty of care means. While the idea of a duty of care on online platforms to take reasonable steps to protect user from Amway at first glance seem to be a logical extension to existing duties of care. There are a number of very real differences which render such an extension unsuitable, and I'll go into them. Number one, existing duties of care only exist in relation to harm that is caused by the individual or entity's act or omission, and not those of third parties. Even where they are on their premises or using their services. I mean, what comes to mind, why putting this together is, for example, you build a 4-bedroom flat building, or a building that has 4 flats, and one of your neighbors is committing crime from one of the flats, one of your tenants, right, is committing crime. What duty of care does the landlord have regarding the crime that is being committed by that tenant? Do you hold the landlord responsible for the crime that has been committed by one of his tenants? So let's bring that to the online space. So all the platforms that we can think of, whether the X, LinkedIn, or anybody, to what extent can we hold them responsible for what people put on their platforms? So the idea is to say that we should carefully look at how duty of care translates into digital spaces, into digital environment. And I'm going to give further example. Please, next slide. I'm sorry for this I don't usually do presentations like this, but I need to put this test in our eyes. The manufacturers of cameras, for example, and those offering photographic processing services, are not held liable if an individual takes photos which are illegal, such as indecent images of children. For example, somebody takes an indecent image of a child. You don't start looking for the person who manufactured the camera. You focus on the person who has taken that picture. Also, it is the individual who commits the prohibited action who is held liable in law, not those who own the premises or provided the product or services which facilitated that criminal offense. The duty of care in the context of online platforms will make them liable for the actions of third parties, that is, for individuals generating or sharing particular forms of content or acting in a certain way. The fact that online platforms could, in theory, restrict or moderate such forms of content and activity does not change the fact that does not change the situation. The owners of premises can, in theory, remove people who commit criminal offenses through speech, and those who offer photographic processing services could, in theory, review all photographs and refuse to process those which contain illegal images. But they are not held liable if they fail to do so. To hold online platforms liable simply because content is generated or shared via their platforms, or users act in a way which is illegal or harmful, will run entirely contrary to existing duties of care and create an inconsistent system of liability. These are our thoughts. It's open to debate. Second, existing duties of care only exist in relation to harm which is objectively measurable, such as physical harm or financial loss. However, the proposals in the UK online harms white paper largely related to harms which were not objectively measurable, such as emotional harm, distress, or impact upon electoral processes, particularly those harms which have a less clear definition. While the risk of a person being physically injured does not particularly depend on any aspect of that person, the risk of a person being bullied, trolled, coerced, or intimidated will depend greatly upon various aspects of that person's personality and other characteristics, as well as the context in which the words or behavior occur. It is therefore far more difficult for an online platform to determine the likelihood of such a risk materializing and how to prevent it from happening in a way which will not also curtail identical or similar words or behavior which do not cause harm. I guess that explanation is clear. I mean, what basically this is saying is that things that could happen online, such like bullying, trolling, coercion, intimidation, are not exactly the same thing as things like physical abuse. So if somebody is physically abused, it's a straightforward thing. Somebody abused somebody physically. But things like somebody saying that I feel bullied, I feel trolled, it depends on individual to individuals. You could say something to me, I don't feel bullied about it. You say to another person, the person feels bullied. So it becomes subjective in that context. Exactly. So let's go to the next slide, please. Third, there are just 5, so we're already almost done. Existing duties of care only exist where the risk is created by the actions or omissions of the individual or entity subject to the duty. However, the duty of care proposed in the UK Online Harms White Paper was intended to apply to companies merely by offering an online platform by which individuals can share or discover user-generated content or interact with each other, which is not in itself a risk. Just as those who manufacture paper, pens, mobile telephones, cameras, and video recorders all develop tools that could, in theory, be used by individuals to say or do things which are illegal or harmful, there is no duty of care owed by those manufacturers to those who might be harmed. While the specific action or omissions of an online platform might create a risk, for example, if they use a particular tool to filter or curate content, the duty of care would not only apply in such circumstances, but simply through the provision of a platform in and of itself. Such an approach suggests that enabling individuals to create and share content and interact with each other is in and of itself the creation of risk. However, no duty of care has ever existed, nor has been proposed in relation to such offline circumstances. Fourth, existing duties of care do not pose risk to human rights. Obligations to protect individuals from physical harm or financial loss, for example, do not create any risk to human rights through compliance or even over compliance. It is not the same when we talk in the online context. They do not therefore require the same sort of safeguards that are necessary when actions are taken, which risk restricting human rights. As such, while simple measures such as a requirement to act proportionally may be sufficient when it comes to existing duties of care to mitigate risk related to compliance, such as disproportionate expenditure, these are not sufficient when for a duty of care which impacts upon and creates risk to freedom of expression, as would the duty of care set out originally in the UK Online Harms White Paper. Fifth, not 50 years. Okay, 50 years. Fifth, people are happy that I've gotten to the end. Fifth, and it's very long. Fifth, and related to the above, existing duties of care require a preventive approach. That is to identify where risk might occur and then take steps to mitigate them. Such an approach might be suitable in relation to risk of physical harm in a particular physical environment. It is not appropriate when it comes to restricting different forms of online content and activity. The duty of care proposed in the UK Online Harms White Paper will require online platforms to take reasonable steps to protect users from harm. And as noted above, the proposal suggests that this would mean going beyond simply ensuring that users are able to report content which is harmful so that it can be removed, but also taking steps to prevent users from even coming across such content in the first place. As such, the model proposed implied a preventive approach, sometimes referred to as prior restraint, rather than a reactive one. There are two main ways that online platforms could, in theory, prevent users from coming across harmful content, which will be consistent with this preventive approach. The first is to prevent it from everything being made available on the platforms through checking every single content beforehand, in practice through machines. The second is to proactively and continuously monitor all content on the platform and remove content as soon as it is identified with the hope that it will not have been seen. Were the equivalent measures proposed in the offline world, they will unquestionably be violations of the right to freedom of expressions and the right to privacy. Such proposal would, without question, be disproportionate ways of addressing illegal and harmful speech that depart from the joint declaration issued by the UN Special Rapporteur on Freedom of Opinion and Expression, the Special Rapporteur for Freedom of Expression of the Inter-American Commission on Human Rights, OSCE representative on freedom of the media, and the African Commission on Human and People's Rights Special Rapporteur on Freedom of Expression from 2011, establishing guidelines to protect freedom of expression on the internet. Open quote, at a minimum, intermediaries should not be required to monitor user-generated content and should not be subject to extrajudicial content takedown rules, which fail to provide sufficient protection for freedom of expression, which is the case with many of the notice of takedown rules currently being applied. I mean, the point here is very glaring. The point is that if we are going to go by what was proposed in the UK online harms white paper, what it will mean is that platform has to proactively do it. And proactively doing it means that they have to literally monitor what people can say or what people are saying online. The type of conversation we are having today is not an easy conversation, and there is no easy solution to the problem. But it's very important that we don't run away from the problem. And it's also very important that in the course of trying to solve the problem, we then create new problems, just like we discussed earlier about the Cybercrimes Act. Next slide, please. So there are other things in the white paper that we provided feedback to. One of the other concerning issues is also defining harmful content. There is proposal around harmful content as well. Then how do we define harmful content? Next slide, please. The definition needs to be limited for the purpose of establishing legal obligations around it. Otherwise, it will become incompatible with the permissible restriction of freedom of expression according to Article 19 of the ICCPR and other international human rights norms and standards. I think the point here is also clear about the problem with saying something is harmful is that harmful is not the same as illegal. So if you say it's harmful, is it also illegal? Is it also an illegal content? And also, to what extent do we determine, when harmful content okay, I think let me put it differently. Should harmful content be punished or simply taken away from platforms? These are some of the conversations we need to have. We had a conversation earlier about what is happening with the Cybercrimes Act and how police sometimes choose to interpret provisions in the Cybercrimes Act. Also, when you make reference to things like harmful, it can also be subject to different interpretations. I think that's the point being made here. So it's also something we need to carefully define. So if we are going to create whether a law, whether we call it a framework, a policy, we have to carefully determine what we would refer to as harmful that will apply within the context of that, whether law, regulation, whatever name we call it eventually. The UK Online Safety Act is taken as reference for the definitions included in our own white paper. That's the white paper we are talking about. However, the current draft lacks sufficient acknowledgement of the evolution experienced by the Online Safety Bill in this matter to the finally enacted legislation. I think the point here basically is that we must also be willing to go through the rigor of processes that will eventually lead to the final destination. And I'm sure that we are committed to do that. This is also part of that process. Let's go to the next slide. The definition of harmful content has been limited and tailored substantively. Oh, sorry, next slide, please. I think that was repeated. Oh, let's just go to the next slide. I don't want to bore you with too many tests. Okay, sorry, let me read the second paragraph. This is relevant. The latter doesn't mean nothing can be done regarding it, but rather the measures, policies, and legal obligations should be different. So the point here is that we are not saying let's ignore harmful content. We are only saying that what we do in terms of measures, policy, and legal obligations should be clearly different. In page 44 of the white paper, I'm sorry you have not seen the white paper, but it will be published very soon. When describing the proposed framework of OHP is Online Harms Protection. The duty of care is limited for concerning illegal content and materials harmful to children, but there is also reference to other responsibilities depending on platform provider skill for actions on harmful content to children, materials with significance to civic and democratic participation, and journalistic content. This is a critical point on the scope of the proposed OHP that should be navigated carefully considering the international experience. OSA is Online Safety Act, DSA is Digital Service Act, and UNESCO guidelines. And respecting freedom of expression according to Article 19 of the ICCPR in order to fulfill its goal of safeguard and promote freedom of speech in the online space. So lower hanging fruits, this is one of the feedback we have already provided. The white paper makes reference to development in some jurisdictions such as Germany NetZDG, Australia's Online Safety Act, and EU's Digital Services Act, Ireland's Media Regulation Act, and UK's Online Safety Act, regarding work already done in the area of online safety. However, there is a clear argument to be made that in the Nigerian context, the lowest hanging fruit is the ongoing process to amend the Nigerian Cybercrimes Act 2015. The ongoing process proposes a two legislation that addresses cybersecurity issues on one side and cybercrimes on the other. Am I correct, Ministry of Justice? Okay, please correct me. So I said that the ongoing process to amend the Cybercrimes Act proposes a two legislation, one addressing cybersecurity, the other addressing cybercrimes. Correct, right? Yeah. So what I'm saying basically is that this is a lower hanging fruit that can help address some of the concerns that the proposed online harms protection bill is also seeking to address. While efforts to introduce similar legislation to those referenced above may be laudable, Nigeria's concerning history of abusing laws, legislation aimed at addressing harms, calls for a strong, cautious approach. This last statement is just saying that, context is everything. We have made very clear argument around effort that has been made in other jurisdictions to address online harms, which then give us, in a way, some justification around why we should come up with the same sort of, legislation in Nigeria. But we must not overlook our context as a country, because our context tells us that legislations like that are typically abused. And I don't think I need to expand on that. We've talked about it today, what has happened with the Cybercrimes Act. Next slide, please. The gaps within the Nigeria regulatory frameworks of content moderation and online harms protection. While exploring gaps within the Nigeria legislative frameworks, specifically with the Nigeria Child Care Act, the white paper proposes a robust protection from online harms, which should establish clear guidelines for online platforms regarding CM. I'm not sure what is CM. I can't remember what. Yeah, sorry, content moderation. Yeah. Introduce measures to protect vulnerable users, especially children, and balance the need for content regulation with the protection of freedom of expression. So these are our thoughts on this. Wouldn't it be better to approach to amend the gaps identified in the Act instead of proposing to fill them through a new legislation? That's just a question. It's not, that's more like a question for us to think about. Also, regarding mainstreaming human rights, you would recall that when Abraham made the presentation earlier, she did mention that the process actually started as a digital rights and content moderation effort before it graduated into what we have now. So which means that right from the word go, there was this deliberate effort to ensure that digital rights was mainstreamed in the process right from the beginning. So in terms of mainstreaming it, our opinion is that the suggestion that the proposed OH bill addresses human rights violations online doesn't help to contextualize actual digital rights issues that must be safeguarded with or by the proposed or appropriate legislation of the state. The proposed OH bill, while serving noble objectives, should not pretend to have at its core the protection of digital rights, as it will not be able to adequately do so. However, the digital rights objective for the proposed bill is for the white paper to articulate how the proposed bill will have safeguards that ensures that it is not used to abuse rights, target journalists, human rights defenders, opposition political parties, activists, and citizens generally. For example, specific references should be made to international human rights laws and standards. See the UN Rabat Plan of Action on the Prohibition of Incitement to Hatred as an example, or as some sort of inspiration in terms of how to go about that. Such measures that should be articulated include. So this is also saying that should we eventually decide to go with the OHP bill, then we need to clearly articulate in the bill how will we ensure public/judicial oversight on the law? How will we ensure mechanism for transparency in the implementation of the law? How will we create rights to effective remedy, etc., and other measures that ensures that rights are protected? The next slide, please. Also, the proposed approach to address hate speech, that is in bullet point 2 on reporting mechanism, must clearly define the role to be played by the proposed center and others in seeking redress. So one of the things that the white paper has proposed is to create a center that will, implement this. So what this is saying is that what role will the center play in addressing hate speech? Next slide, please. So the proposed Nigeria Center for Online Harm Research Prevention and Coordination, NG/COHRPCO. Could this function be performed? This is a question now. Could this function be performed by an existing institution or housed in one? Creating new agencies be additional cost and bureaucracy. We shouldn't be throwing out those. I already spoke to this earlier today. We were talking about cutting the cost of governance. To what extent can we make an argument to create a new center? So should we explore housing this in an existing institution or agency of government? Let's go ahead. The next slide, please. Proposed framework for online harm protection in Nigeria. It might be good to reference the UNESCO guidelines that offer support for a co-regulatory approach. So also talking about co-regulatory approach, we're also making reference to this UNESCO guideline. Next slide, please. I've been told to wrap up. I'll try and wrap up in the next few minutes. How many more slides do we have? Okay, I think I'll just skip some of this. Just skip this. You can skip this as well. Okay, that's all. Just go back. Let me just run through it and finish it, please. It's not much again. Just go back to where I was. This is where I was. So, operationalizing online protection regulation. Obligations of public and online platforms. References to monitoring must provide further clarification on how this is compatible with freedom of expression. So, if we are monitoring, what are we monitoring? That screams surveillance. Global online platforms compliance. Any takedown obligation should also be established in a proportionate way and fulfilling Article 19 ICCPR 3-pass test. Council, can you help us with the 3-pass test? This ICCPR 3-pass test.
Okay, for the 3-part test, generally it says that for any action, for you to take any measure, you have to first make sure that there is a law in place. So the law must have been formulated with precision, that everybody can know what their obligation is under that particular law, so that they can take, they can take the necessary steps not to violate the law. Then the second law now says that it must law or the measure you want to take must pursue a legitimate aim. Now, the legitimate aim usually is the usual thing that the government comes up with and say public safety, national security, and all that. And so that then takes us back. Even when you've done your legitimate aim, it now goes to the third one, which says that whatever measure that you are taking, it must be necessary in a democratic society. And it's that necessity that then embodies the issue of proportionality. So whatever measure you're taking to address your legitimate aim, it must not be disproportionate at any point in time. So under the ICCPR, those three requirements, the 3-part test, they are cumulative. It's not for you to say that you already have a law in place and that takes you out. So for instance, when we filed a case against the Sokoto government for shutting down telecommunications in Sokoto State, the judge could not see from this perspective and still held that NCC had a rule and a regulation that permits them to shut down telecommunications. But at the end of the day, the question should still remain, was that act proportionate? At any point in time, should the government be able to shut down its people because bandits are using the same phones to make calls? Bandits who have access to Raya, for instance. So at the end, those are the kind of questions that the 3-part test raises for us.
Detailed presentation. I don't know, maybe because it was very comprehensive. And when you put things together like this, adult class, sometimes we miss the issue of AI, artificial intelligence, generated images and videos, etc. I don't know how much is captured so far. I don't know how much is captured, the issue of AI in this whole, in the bill so far. Maybe I missed it, or maybe it's somewhere hidden. But I think it's emerging, as you know, it's something which we really need to bring up strong. And that's one. It's in the okay. So, and secondly, of course, I subscribe to the fact that we shouldn't have too many other laws. So whatever we're trying to do, let's just incorporate in what we have. Ditto for structures, whatever are the existing structures, so let's create another commission, because we have so many and we're even trying to streamline. So whatever we want to do, let's use the existing structures that are there and let's make it as technical as possible, whatever is the structure, not political. I know it's difficult, but especially this kind of scenario, let's make it as technical as possible and as divorced as possible from political interference. Thanks.
Thank you very much. There were some questions raised during the presentation that I think the presentation already indirectly answered when it said NGCOHRDCO, should we have a body of organization? And there was this use of language, co-regulatory. So I don't know how co-regulatory is similar to public-private partnership, which I think is best. Where government does not have to take charge of everything when it comes to issues on the table, and then people can talk about it. And then we also have something like an acronym that should fit such an organization, which is Content Moderation Organization. I differ with the last speaker on the issue of merging it with other or existing acts. Why? The reason why it's good as a standalone from the presentation is that you can easily address it. You can easily study as a first line of defense, begin to study similar informations that come online. When those informations come online and the Content Moderation Organization can say, this is part of the content that we are talking about. It is not an illegal content, but it's an illegal activity on a particular third-party platform or on a platform that needs to be addressed. Let me take a name, like maybe there is a platform called Nigerian Faces. And then the Nigerian Faces allows different identity to come online. And then someone dubious comes online and tries to market something. It would cause harm to someone, either financially or otherwise. And then you, as the owner of that particular platform, already understand that there are complaints about that particular individual or organization or channel. There is a responsibility for you to show your duty of care by taking action. And there are other ways that you can do that. There was a discussion with someone with the Child Online Protection of an organization here in Nigeria, NERA to be precise. And I said there are some content on a video platform that allows for educating our children in the wrong way. How do you take them out? If you can't take them out, then you reduce the visibility in the country. The content from some particular organization online is different from, okay, maybe I should mention him since we are not live streaming. The content you get in Japan, I think, or China on TikTok is different from the content you get in other countries. While in Japan, they will teach you digital skills, hands-on skills, DIY. You get other things here in our part of Africa, to mention Nigeria, to be particular. So that is why we need to set it aside. It is not something that we need to rush into. We have to learn the ropes, and that's why that organization will be very, very important. Then finally, on the issue of fact-checking, again, the Content Moderation Organization, which will be a PPP, I propose, from organizations either in the sectors of child online protection, media psychologists, that we need to pay attention to media psychologists. This would help us be able to scale through and define a much more stronger, at the end of the day, duty of care, or what we call the online harms protection. Thank you.
I'm Adebayo Are from the Center for Journalism, Innovation and Development. So my question is actually as regards the presentation made earlier by Mrs. Sorry, I forgot your name. So she mentioned that the aim of the online arms protection bill is to foresee some of the challenges that may arise with the usage of technology and, by extension, technological platforms, so that we can prevent them ahead of time. but I just want to know if this activity or the exercise is also taking cognizance of avoidance of preemptiveness, such that we don't in the process of trying to have a foresight about what is possible to happen, then use that medium to create problems that might not even be going to happen or might be unlikely to happen. I don't know if my question is clear enough.
Okay, I just wanted to make a little observation from the last presentation. I noticed he made mention of something like a Child Care Act. Just to correct, that there's nothing like a Child Care Act. What we have is the Child's Rights Act of 2003. But also just to, and then state, because of the contention around the issue of what child's rights, many states have, and then because it's on the concurrent legislative list, states are enjoined to domesticate it to suit their context. So many states have fine-tuned it to whichever nomenclature they decide. But also to mention that the Child's Rights Act is not yet domesticated across all the states in Nigeria. Some states are still under the Children and Young Persons Law. And unfortunately, under that law, age of majority is not 18 years. What we have is age of criminal responsibility, which is unfortunately 7. So, I mean, that is also another thing to look at, that some states in Nigeria don't have 18 years as the age of criminal responsibility. Or thank you.
So two things. I'm a bit confused because if NIDDA is the one steering this online harms bill, so I think 2-3 years back, they did something on interactive computer service platforms. And then while the last person was presenting, he talked about the white paper of the UK and how he said something about it not being, if they follow the way of the UK, in that they will govern platforms and tell platforms that, okay, you should moderate and you should check. But NIDDA already has something that tells you that service platforms should, once they get maybe a court order or they get a complaint from a user or they get a complaint from a government agency, that they should look into that complaint and then they either take down. So it's basically content moderation. They are still talking about what this OHP is trying to do. Secondly, if you look at that interactive service platform, it tells you, it gives you definition of harmful content, disinformation, misinformation. And so I think maybe my issue is because we've not seen this white paper, so we are just talking above our heads, and we are just talking into the air. But if from the little we've heard that this law or this bill is may or may not be put into law, then there's a lot of things that the law that it seems is going to replicate. Two, we are talking about a center. He mentioned a center, maybe an overarching MDA or whatever. So for me that was in the development sector before and now in the government sector. While I was in the development sector, we worked on the VAP. Till today, the overarching center that they've said that VAP should that should govern the VAP, which is NAPTIP, still has issues. So you're now bringing new one that another center would centerize, and I'm wondering, how do you think this would work? When you get my question.
Good afternoon, everyone. My question is about this blockchain technology. The government, as you have been seeing, they are banning so many things about the crypto, they will say in Nigeria. So, but if you are still in Nigeria and you are still doing it, it's like you are doing a crime. So how can the government and the private sector come together to address this issue? Because we are the youths, not only the youths, we are missing a lot. And the country is going through economic situations. So we don't want to be missing big opportunities like this. How can they come together to resolve this issue? So at the end of the day, we can generate revenue for Nigeria. So, thank you.
And have already been reiterated by some members of the steering team. You know, and as Boye mentioned, some of the points that he highlighted, he's even yet to send it to the secretariat. So I've documented most of what had been said and will take as feedback, which is why this process is critical. So thank you.
Regarding some of the issues that came up, there was a question around the question you asked about AI, whether there's consideration around artificial intelligence. My simple answer to that is that this process is not looking to regulate artificial intelligence. And I know that there is another process entirely being led by the Ministry of Communications and is it Communication and Digital Economy, right? Yeah, they are working on AI policy strategy for Nigeria, which is a totally different process. I just want to put that out. Then, secondly, the other point about do I remember what it was Ada that said something about there was one of your comments about this process, about the white paper and the UK online safety. So I think one of the things we also want to achieve is to say that while we can reference what is happening in other jurisdictions, we must also contextualize it to our reality. So the idea is not to copy and paste, really. We can be inspired by what they have done, but we should not take it as like something we have to take hook, line, and sinker, like everything has to be adapted. So the reference to the UK online safety process basically is just basically as a guide. Even my presentation was coming more from the place of the criticism of that process. That okay, this is at the criticism of that process. So if we are doing the same thing, we should be conscious of those criticism while we create our own whatever mechanism we decide to create. Yeah, you made reference to the code of practice. Yeah. So my response to that also is that so interesting. That's also a NIDA process, right? And interesting, this is also a NIDA process, and that tells me something that even from the point of view of NIDA, they are not confident yet that they have really figured out what needs to be done because we also have a lot of criticism for the code of practice as well. We have a lot of feedback that we've shared with NIDA. Yeah, so I think, in my opinion, compared to the code of practice, this for me is a better process because this whatever is happening is not even at NIDA's desk yet. Yet we have started talking about it, which tells me that it's a better stakeholder consultation process than what happened with the code of practice.
Okay. And now I would invite Bengas Sheson for a quick word on recommendations, ways forward, calls to action. And for those whose questions have not been answered, one of the things that we're hoping this gathering will do for you is provide access to various stakeholders that otherwise would be busy and you would need to go through many layers to get access to them. So now is your time to speak, network before they run off.
All right. Thank you, everyone. It's been quite an engaging day, and I know we put two different conversations into one day. So I can imagine that not seeing the white paper wasn't exactly very helpful, but that is good. That in itself says something about what is next. I've been asked to talk about what's next. I will not use up the 10 minutes that I was given in the interest of time, but I'll share 6 quick things. Number one is everything we've said today points in the direction of more cooperation. I love it when I hear one representative of a government agency say to the other that you need to think through something properly. I love it. I love it. Because if we don't collaborate more, and when I say collaborate more, I'm not just talking of government agencies, I'm also talking about civil society. Because I think it's general that working together is a bit more difficult, to be honest, because there are things you have to do, you have to work hard, and to now cooperate is going to be extra work. But I think that is something we all agree on today. The second, which is related, is the need to have a lot more difficult conversations. You know, one of the challenges with meetings like this, thankfully, that didn't happen today, is that people tend to be politically correct. And in the name of being politically correct, we leave out the elephant in the room and we don't address it. But I think it's one of the major reasons why it's important to have difficult conversations is that at the end of the day, our hearts are all in the same place. You want a better Nigeria for yourself, including the people, to be honest, some of the people who even go ahead to arrest people illegally at times. In their own mind, they are doing it because they want to keep Nigeria safe. It's the same objective. So it's important for us when we disagree to bring bubbly to the surface and not pretend. You know, around here, I joke that Nigerians are the most polite people I know. If I come out here and I make the worst presentation in the world, when I finish, you will clap. Somebody will come and meet me after and hug me and say, Benga, wow, you speak so well. We're so polite, but in that being polite, and this is one of the reasons why we don't push back many times when we ask for things. Every agency says, give us biometric information. You say, yes, sir. Every agency, yes, ma'am. Once in a while, we need to push back and have these tough conversations. I'll give you a very perfect example. NIMSI is going to hear from us on this issue. I say this publicly, and I know as I'm saying it, I'm stylishly reminding my colleagues that the court is waiting. This will not go the former ways. It's impossible. But at the same time, we are partners with NIMSI. NDPC will be joined in that lawsuit because you've shared your responsibility. But as I leave here today at 2 o'clock, I'm going to sit inside NDPC's office to draft GAID, the General Application and Implementation, directives for Nigeria. That is how we need to work together. When it's time to sue you, we'll sue you. When it's time to work together, we work together. Because at the end of the day, it's not personal. In 2013, somebody thought it was personal when we said, was 2013? Yeah, 2013. We went to the NSS office and said, you need to be careful all these new things you are investing in, all this surveillance equipment, all this. Because if you leave government, it will affect you too. You know who was NSA at the time? Dasuki. Do I need to tell you what happened to him when he left? No. Everybody will get the Dasuki treatment. So why not just create a level playing field for everyone now so that when you get your Dasuki treatment, they will not use the bad things you created against you. We were going to sue Dasuki, by the way, for plagiarism because he used words about human rights and things like that we normally use. That's a joke. That's a joke. That's a joke. That's a joke. The third point quickly on the Cybercrime Act, it needs more work. We've just got, it is difficult to amend something that has just been amended. It's very difficult. But for this, it takes me to my fourth point. We're looking to the Justice Ministry. I had a very quick chat with you after that, and I said, thank you. Thank you for your spirit of whole of government approach. And we want to rest a task on your shoulder. And that task is, we know you're planning a consultative session. Please give us good notice. So that when we hear it, we'll tell everybody else. And when you plan for 400, just keep in mind it may be 800. And add a virtual component, please. Please, let's add a virtual component. I'm sure that Khadija has, some resources to support with that if necessary. She'll kill me if she hears that. Where is she? Oh, she's not in the room. Oh, all right. The other is, and this is still to the Justice Ministry, a question that was asked today, I think should be a project for you. Documenting what has happened with the Cybercrime Act. We have been documenting, and we're telling the story. And all the things we're documenting, you may say we're biased because we're only documenting, which is the truth, we're biased. Everyone is biased. Our angle is to make sure human rights is respected. So we've been documenting abuse of human rights. If there are cases where the law has been used to save Nigeria from trouble, please let us know. We don't know. And it will be great at the end of every year. And this is one of the reasons, by the way, why I think every government institution should do what non-profits do. Every year we produce annual impact reports. It should only be in 2027 that we will now see Tinubu's scorecard when they want another term. Now, I almost called him Mr. Fagbin. I'm sure I can. Mr. is fine. I'm sure it will do him good to also produce a scorecard of the Cybercrime Act so that it's not just NGOs that are producing their own report. The government also produces a general report. And just before you go, Justice Ministry, there's a very strong need to review ongoing legal action against this cybercrime law. The ECOWAS court has released a judgment. I know you've seen it, and I know it informs some of the recommendations you made. There's also the fact that, as Mr. Ojo said earlier, you are friends with the Supreme Court. It will be great for us to see the Justice Ministry's position on some of these legal challenges. It puts you in a very difficult place because it means you're a implementer of the act with the NSA. You are also the lawyer for the people, literally, Attorney General of the Federation, and also Minister of Justice, which, by the way, is one of the reasons I think we need to separate that office, but I didn't say that. Digital agencies, every other agency from NICTA to NDPC, to the ones that have independence in their names, and the ones that do not have independence in their names but must be independent, we think that it is important, and in the spirit of speaking the truth, let's have less tough wars. Every agency doesn't have to create a project if something is already up, which is how we got here with data, where everybody now has their own data. Immigration has, they have their own. If you want to write exams, you also have yours. But it's not just digital agencies. Also, civil society organizations, we need to pay a lot more attention. It costs a lot. It takes a lot of energy to find out what is going on, right? To find out, we're daily monitoring what is happening at the National Assembly. It takes a lot of energy for that. We're monitoring. One organization cannot have enough resources. If all of our funders, including the Netherlands embassy, say, okay, we will give you 1 million times what we give you already, we will still not be able to do all the work that Nigeria requires. So we need, to work together, which is why we're here. And the last thing I want to say is see you tomorrow. Because tomorrow holds a special place in my heart. Tomorrow we will have a conversation about the Digital Rights and Freedom Bill. That is something that almost happened in 2019, but President Buhari decided not to sign. And as I always joke, it will, by God's grace, be alive when the bill is signed into law, and it will benefit from it. Because it is not in the interest, it is not personal interest. It is to protect the rights of all Nigerians, including those who oppose the bill and those or the person who refused to sign it into law. Thank you very much. But I think my colleague Nena will do a better job at saying the thank you and closing us out.
So, distinguished ladies and gentlemen, friends and stakeholders, we have one final order of business. And thank you to those who have already started filling. Samuel, please, how many do we have? 4. Okay, there are around 60 of us, so that's nowhere near. It's not even 10%. So before we leave, I would like to get that up to 80, 90%. It takes how many minutes to fill? Less than 5 minutes. So before I say thank you to everyone, you would have finished filling. So please, I think we have the QR codes on our table. Kindly scan and help us. We want to get feedback. Do we feel today's deliberations have been fruitful? Hello? Very fruitful. So we would like to know, have they been impactful? What can we do better? Did you have enough time to speak your mind? We want to know those. So please, someone will be giving us a play-by-play, giving us commentary on what we are getting. So, yes. I believe it has been a very fruitful day of deliberations and collaborations. Hello? Thank you. Given the contributions we have seen today, I see this as a safe space. Benga was talking about, pushing back. And one of my colleagues earlier during the tea break was saying, oh my God, this session, I feel so sorry for the Ministry of Justice. It feels like everybody's attacking them. And I told her, I said, we're partners, but we have to hold each other's feet to the fire. we have to hold each other accountable for our parts in any joint or collaborative efforts that we have. So it's been great to see the wide-ranging conversations that we have had today. And thank you for everyone for the constructive feedback that I think all the contributors, all the presenters, everybody, all the stakeholders and agencies have received. I want to extend my heartfelt appreciation to each of you for your valuable contributions, for your active participation and your attention, and for working to lay the groundwork for meaningful progress in safeguarding digital freedom. I want to especially thank our partners, the Embassy of the Kingdom of Netherlands, whose partnership has made this event and this engagement successful. We thank them for their continued and invaluable support in our shared vision of a rights-respecting world. To the representatives of the government stakeholders present who honored our invitation, NIDA, NDPC, the Ministry of Justice, thank you for your presence. Thank you for your insights and your support. Your expertise and guidance significantly contribute to the development and refinement, which is what we're doing today and tomorrow, of legislation that upholds digital rights in Nigeria. Thank you to all our civil society partners in the room. I was going to list everyone, thank all the speakers who have spoken, thank all the organizations, familiar faces I've seen, but if I do that, the speakers that spoke when I wasn't in the room, I won't have their names, so I'll say a thank you to everyone. We're really grateful for the continued dedication to advancing digital rights and digital freedom in Nigeria. Thank you for your tireless advocacy, and thank you for mobilizing support and amplifying voices to drive meaningful change. I want to thank the press that's covering this event. As I said earlier today during the opening, it's not just for us to, work in silos and have these engagements, but to also use these engagements as a platform to raise awareness and mindshare of these legislations and their implications to the general public, because I feel that when concerned individuals like you and I know the impact of laws in their lived everyday lives, we will get the support that we need to push back against repressive legislation and to push for the development of rights-respecting laws. To my team, I think as we're doing this, maybe please help me give a round of applause to my team, Boye, Khadija, Adeshui, Dinchi, Lillian, Samuel, Ifyok. They're in and out. You've seen them around today. Thank you so much for your tireless work to ensure that we have 2 days of really engaging and deeply impactful conversations. Even though we're having dialogue and learning, I'm glad that we are working together on actions. We're documenting this process. We have rapporteurs in the room. Thank you to our reporters. And we will be sharing the outcomes and action items for the near future. The goal is not just to deliberate, but to obtain commitments. And I think Benga has shared some action points for each stakeholder in the room. It's to gain commitments from all of us in the room and our respective agency circles or sectors on joint actions to ensure that we amend and refine rights-harming legislative articles, which we have reflected today. I trust we will carry forward the momentum that we have generated from today's discussions into tomorrow's deliberations.